Lordship sees page 26. From 3591, the assessment is paid to the Bhavnagar Nagar Palika. So assess, and then page 27 also in 2012 also is paid. Subsequently, all the petitioners have been paying assessments. This area is covered under the slum list as published by the Bhavnagar Municipal Corporation. So, Lordship, the submission which I made yesterday was, and I repeat again, is that, Lordship, this entire process is illegal because the notice firstly alleges that there is illegal construction and without any sanctioned permission. Enough opportunity is not given to respond to that at just 2 days' time. The printed form in the notice says that you can respond within 7 days. On page 19, if your Lordship sees the printed form. Page 19. But after the બાંધકામની વિગતો ઉપરોક્ત હકીકત આ બાંધકામ ભાવનગર નગરપાલિકાની મંજૂરી વગરનું નિયમો અને કાયદા વિરુદ્ધ હોવાથી આ નોટિસ મળીથી તાત્કાલિક બંધ કરી દેવાનું રાખશો. તેમજ આ ગેરકાયદેસર બાંધકામ બાબતે દિવસ 7માં જરૂરી આધાર પુરાવાઓ સાથે ભાવનગર નગરપાલિકામાં બિલ્ડિંગ પ્લાન મંજૂર કરાવી લેવા અંગેની કાર્યવાહી હાથ ધરવી, જરૂરી આધાર પુરાવાઓ રજૂ કરવા, જરૂરી સ્પષ્ટતાઓ દિવસ 7માં રજૂ કરવાની રહે છે. તથા જો આ બાંધકામની બિલ્ડિંગ પ્લાન મંજૂર કરેલ હોય તો તે અંગેના જરૂરી આધાર પુરાવા આ નોટિસ મળીથી 2 દિવસમાં રજૂ કરવાનું રહેશે. So Lordship, in sum and substance, if we see this and then last question, આ બાબતે આપના તરફથી દિવસ 7માં જરૂરી સ્પષ્ટતાઓ આધાર પુરાવો જવાબ વગેરે રજૂ કરવાની થાય તો ભાવનગર નગરપાલિકા દ્વારા આ ગેરકાયદે બાંધકામ જીપીએમસી એક્ટ 1949 ની કલમ 260/2 अनुसार આપના ખર્ચને જોખમે દૂર કરવામાં આવશે જેની નોંધ લેશો. So the printed form records that this has to be done within 7 days, whereas in by hand written they give period of only 2 days, and thereafter they pass the order. Not sure in that context I had submitted the judgments of the Honorable Supreme Court with respect to that. I may just again submit that. Lordship, first is 2019. 20 SCC 2019 20 SCC page 781. Now, Lordship, this judgment is pertaining to the BPMC Act as applicable in Maharashtra and the Mumbai Municipal Corporation Act 1888, where the Honorable Bombay High Court in para number 3 had issued directions as to how the proceedings under section 260 had to proceed. The Bombay High Court in 1996 said that there has to be 15 days notice under section 261, and then after the order there has to be 15 days before demolition. Now, Lordship, this was carried in some other matter before the Honorable Supreme Court. The Honorable Supreme Court has approved this because this direction in para number 13, if your Lordship sees. 10 is that the 7 days time was given for 260 into bracket 1 notice, and then 15 days has been approved. Lordship, I may just read para 13 so that my learned friend, serious friend also has an opportunity to note the judgment. However, as appointed by Mr. Javeri, so and so, learned counsel appearing before the respondent, the second direction in Sopan case requiring 15 days notice to be given to the affected person before demolition of structure is still valid, and therefore 2 notices are required to be given, namely show cause notice of 7 days in terms of 351(1)(a) and 15 notice of 15 days in terms of Sopan case 1. The learned counsel also submitted the judgment in Sopan case holds field till date, and we agree with the counsel that in terms of direction 2 in Sopan case, 15 days notice has to be given before demolishing the structure. We are not oblivious of the fact that subsection 2 of section 351 does not lay down any timeline in this regard. It was in this context that when no timelines were laid down either for show cause notice or for demolition, the Bombay High Court in Sopan case fixed 2 timelines of 15 days each for issuing show cause notice and thereafter to take action of demolition. The legislature intervened and the first period has been curtailed from 15 days to 7 days, but the second direction has not been interfered with by the legislature. Therefore, the judgment continues to hold the field in this regard. Admittedly, in both the cases, second notice does not comply with the direction in Sopan case. Therefore, there is no manner of doubt that the requirement with regard to second notice has not been complied with in either of the cases. As such, the action of illegal demolition without following the procedure prescribed by law is illegal. So this was one of the judgments. Then the other judgment that I had relied upon was of 2019 6 SCC, page 150. 6 SCC. 150. Here, if lordships may note, placetum G, almost similar notice has been issued with respect to illegal construction on page 151. Placetum G, if lordship knows, show cause notice. It has been reported to me, am I with your lordships, that you have carried out the following unauthorized constructions without prior permission in shop number 5354, Ghosi Mohalla BI Bazar, Meerut, Kent. Same allegation. Now, these notices were quashed by the High Court, and against that, the cantonment had gone to the Supreme Court. And what the Honorable Supreme Court passes order in para 7. Another ground before High Court was that the notices are issued in casual manner in spite of submitting the reply to the show cause notices. The primary authority has not considered the replies and passed order, and even appellate authority has passed stereotype order without giving any opportunity fixing the date of hearing. First two grounds raised by the respondent writ petition were not accepted, but however, High Court has held that a reply filed by respondent original petition was not considered and no reasons were assigned for rejecting objection. Further, it is also held that the appellate authority has passed orders which are more or less identical and passed in predetermined manner without giving any opportunity of hearing. While quashing the impugned notices, the High Court by the impugned order dated so and so left open to the appellants to proceed afresh in the light of the observation made in the judgment. My submission is here. Similar is the case here in stereotype order under section 260 into bracket 2. Para 12, if your lordship sees. If I may just read from 4 lines from bottom. It is the case of the respondents. It is the case of the respondent where objections are filed and their objections were also not considered. Having issued show cause notice, the primary authority ought to refer to such notice and objections, if any, to such notice while issuing the final notice on 2/9/2006. It is clear that notices are issued mechanically in casual manner. Even the appellate authority, relying on the survey report dated 10/8/2006, has held that the respondent in civil appeal number so and so has raised unauthorized construction on first floor of the shop without taking any permission of the competent authority. Further, it is stated that the survey inspection report is not furnished to the respondents at any point of time, though such notices are relied on for rejecting the appeals by the respondents. While quashing notices in the impugned order in the writ petitions filed by the High Court, the High Court has left it open to the appellants to issue fresh notice and to pass appropriate order by following procedure contemplated under law. In that view of the matter, while it is always open to the appellants to initiate fresh proceeding by issuing fresh show cause notices on allegations made against the respondent, but at the same time, having regard to the reasons recorded in the impugned order passed by the High Court, we do not find any error in the order passed by the High Court so as to interfere with the same in these appeals. So, Lordship, such notices which were caused by the High Court, the Honorable Supreme Court did not intervene in that. And Lordships, the last judgment. So there was one judgment which I had relied upon, possibly I am not able to rehand about second copy. That was with respect to Haldwani. Possibly Lordships have on file or it was returned to. No. It's not. I'll just read because Lordship, I had that possibly I have misplaced the second copy. Now, Lordship, this is in the respect of Haldwani, where the occupation on the government land. I got occupation of the railways land was noted by the High Court. The High Court gave 7 days time to evict that, and against which the SLP was referred before the Honorable Supreme Court. While granting the first order and interim relief, the Honorable Supreme Court ordered, Lordship, I would request your Lordship to consider the reasonings for granting the interim relief. If Lordship say page 3 of that order. Page 3, bottom paragraph. Apart from that, there are issues of occupants claiming rights in the land as lessees, auction purchasers. We have a cavil to weigh the directions have been passed in impugned order, as there cannot be uprooting of 50,000 people overnight within 7 days. We do believe that a workable arrangement is necessary to segregate people who may have no rights in the land and those who have but to be removed, but coupled with schemes of rehabilitation, which may already exist, while recognizing the needs of railway. We have put to learned ASG that look may be had to the methodology of achieving purpose of the railways coupled with the rehabilitation process in the area. In pursuance to the earlier Supreme Court orders, proceedings under Public Premises Act have been taken up and culminated in orders. Some appeals are stated to be pending, but without say, those proceedings will go on. Issue notice. Lordship may just skip. Lordship may have the last paragraph. In the meantime, there shall be stay only of the direction passed in impugned orders. That has also to be coupled with a complete restraint on any further occupation of land and or construction, whether by existing occupant or by anyone else. Now, Lordship, in this context, if your Lordship sees the order under section 260 into bracket 2 on page 20. It's a stereotype order without referring to any of the replies. What is the reply? What has been stated? Everybody's reply has been rejected. And if you not just sees the last hukam part. ઉપરોક્ત હકીકતે આ બાંધકામ ભાવનગર નગરપાલિકાની મંજૂરી વગર તેમજ પર્વતમાન CGDCR ની જોગવાઈ વિરુદ્ધ કરેલ છે, જેથી આ બાંધકામ અનધિકૃત રીતે કરેલ હોવાનું સ્પષ્ટ થતું હોવાથી આ અનઅધિકૃત બાંધકામ GPMC એક્ટની કલમ 262 મુજબ આપના ખર્ચે અને જોખમે તોડી પાડવા આથી હુકમ કરવામાં આવે છે. જો આ બાંધકામ આપના દ્વારા તાત્કાલિક અસરથી દૂર કરવામાં નહીં આવે તો આપના ખર્ચે અને જોખમે ભાવનગર પાલિકા દ્વારા આ અધિકૃત બાંધકામ દૂર કરવામાં આવશે, એની નોંધ લેશો. No time limit, nothing, with it immediately. And Lordships may just appreciate the only objection is against the illegal construction, and with respect to all 102 petitioners, because in the other petition there are almost 19 petitioners. In the first there are 100, so 104 petitioners. All have been said because this were hutments existing since 1983 on record, because in 1991 they did a survey, they issued identification cards to everybody that your hutment is prior to 83 or after 83. They have been paying regular taxes as assessed by the corporation, and all of the electricity charges, everything. Now they may have put, I don't say that they may have at that point of time, if your Lordship sees the notice in the first, it's a patranu chapru, it's a tin shed. They may have thereafter put a slab over the period of time, I mean, this 40 years, but without obtaining permission. That may be also there, but that all thing can be taken care of and regularized. At this stage, to just remove all this structure and bring them under sun without any roof, any shelter, would in fact rendering them, ousting them from this premises when they are not disputing the occupation. The occupation is not in dispute because the occupation has been, it's a lease land of the corporation where these husbands have been existing. At this stage also, they are not saying that these husbands are required to be removed for any scheme, for any road, for any.
I would not interfere, but there is no lease.
This
This
is
is an
what they say.
encroachment. There is no lease, nothing is there in the memo of petition, no averment, no document. I'll address the honorable court as and when I get my turn.
Lordship, page 20. Just to answer my learned friend.
No, let there be a lease deed. It is corporation's property.
Lordship, page 20. ઉપરોક્ત વિષય, if Lordship, ઉપરોક્ત વિષય સંદર્ભે ભાવનગર મહાનગરપાલિકા વિસ્તારમાં મફતનગર રાજારામનો અવેડો વાળો ખાંચો ભાવનગર નગરપાલિકાની માલિકીના લીઝ હોલ્ડ પ્લોટ રસ્તા પૈકીમાં જે બાંધકામ કરેલ છે, so they say that it's a leasehold plot.
It is not.
By saying it is not there.
It is not to them.
Lordship, it is not to me, but at this stage, the notice
Not
not
to
to anybody.
anybody. It is not to anybody. It is from state of Bhavnagar, original aspire state of Bhavnagar to municipality, then to municipal corporation.
But Lordship, at this stage, the notice does not say anything with respect to occupation at all. The notice, if Lordship sees page 19, is only with respect to construction. If Lordship says page 19. The objection is with respect to construction.
Yes.
બાંધકામની વિગતો ગ્રાઉન્ડ ફ્લોર પર પતરાનું બાંધકામ તથા માલિકીના આધારો તથા બાંધકામના આધારો દિન 2 માં રજૂ કરવામાં રાખશો. And they don't say that this anything, Lordship, this removal is required or necessitated because of some scheme, some government it being reserved, and therefore some scheme has to come, some road is obstructed, encroachment on public land or encroachment on government land, encroachment on road. Nothing is mentioned. If that is not mentioned today, only objection is with respect to construction. We say, admittedly, which I'm saying that permissions are not there. Nobody had permission because they were existing, they were the old hutmen, which to some extent they have made it pakka constructions over the period of time. Some, but not all. Some have them put up. Now that if construction is in dispute, that construction in my humble submission can be regularized, can be taken care of, but to say that it will immediately demolish, since you could not provide documents within 2 days, in my humble submission, it's too high-handed attitude on the part of the corporation and completely contrary to what the Honorable Supreme Court has said, because yesterday the same provision, section 260, is almost identical to what is there in BPMC Act as applicable to Maharashtra. The judgment of 2019 also takes care of the earlier 1888 Act, which was applicable prior to the Bombay Municipal Corporation Act. And there, section 351 is the relevant section under which notices are issued. The Honorable Supreme Court says, approves the guidelines of Bombay High Court, direction of Bombay High Court, where it says that the first notice has to be for 15 days, and second, after demolition, 15 days. Now, they first notice, they say within 2 days you respond. We responded anyhow. We made lots of, it's extremely difficult, even for a normal layman, to find all the documents within 2 days and submit to the authority. Even if a person, educated person, or some person who meticulously maintains his record, even if he is asked to produce documents within 2 days, it is impossible. Because most of the documents, and over the year, nobody keeps all these documents. And 2 days, and thereafter immediate demolition. So actually, the submission is, at least they may they ought to have followed due process and given enough time to the persons to respond to the notices, consider their reply, and then passed order. Here they are stereotyped order. I'm sorry, I'm moving. Please,
No, firstly, my lord, the titles of the land. No, nothing is there about say.
You are for respondent number 2.
Yes, my lord, Bhavnagar Municipal Corporation. Lord, the land in question, my lord, is of erstwhile state of Bhavnagar. And after independence, it was transferred to Bhavnagar municipality and to thereafter Bhavnagar Municipal Corporation, as it was converted from municipality under the BPMC Act. My lord, land, my lord, my learned friend has not pointed out at any stage during the course of arguments as well as through memo of petition that the land in question is leased to them, that means to the petitioner, or is transferred to them, or they have any right, title, or interest through any documents, legal documents. Property, land in question remains with Bhavnagar Municipal Corporation and unauthorizedly is encroached upon by the petitioners. It is not true that they are occupying the land since last 40 years. They say that they have put up hutments, slums in 1982-83. That is not true. They are not occupying since last 40 years. They have not produced any document to show that it is in their possession since last 30 to 40 years. But the construction is not of hutments or slums. My lord may see the photographs. I am having number of photographs, but they are having
Just
cars.
one query.
They are having cars, they are having 2-story buildings, they are having air conditioners, they are having all latest equipments.
We'll go to that later.
Yes, sir. Yes, madam.
There is one document which they have annexed at Annexure E, page 24.
Yes, madam. Just
some clarification on that.
yes, my lord. Lord, this is
It is issued
That
by
is this-
Mahanagarpalika.
yes, my lord. Jhuppadpatti Ganatri. My lord, it is not indicating the location. Apart from that, my lord, It is not indicating any location. Let us assume that he is an hutman and this is issued by Bhavnagar Municipal Corporation.
This is not the place where they are.
No, my lord, location
Masjid
is not
પાસે?
mentioned. Masjid Pase,
14 નાળા,
Goga Road, Goga Circle 19.
Goga Circle 19.
And my lord, there are no slums. Actually, there are
So there-
houses of 2 stories with various modern amenities.
So this and this is a different
No,
place?
no, it appears so. But apart from that, my lord, their right, what sort of right they have in the property, that is required to be
No,
examined.
right. That is what.
No land,
admitting.
no titles,
Show me the
no
photograph
development
now.
permissions,
Let me see the
no sanction plans,
photograph.
and these are the photographs. My lord, recently, last month, in month of April, yes, there was a matter before my lords. My lord, there the honorable court has said that issue notice and take action. Our high court has said so. Please, sir. Madam.
This is Patra?
Yes, my lord.
This is what you call?
My officers, my clients are present. They have brought it today.
Well, actually, what I said is somebody, there are 102.
No, all buildings are there like this, my lord. It is not a single, otherwise there would have been photograph from my learned friend's side. Not a single hut is there. Not a small slum is there. My lord, they are car owners. My lord, must see the nature of construction, quality of construction. It shows that it is just like building or this just like a bungalow or tenement. Only a direction in identical matter was to issue notice. My learned friend's contention is only that they are not given sufficient opportunity.
Yes, that is the only content.
That is the
Yes.
only contention.
Yes,
My lord will
Commissioner.
keep it after 10 or 15 minutes. I'll talk to my client,
Yes.
commissioner.
Yes,
Yes, all right.
these are your places.
Rashida, I am also not aware. I'll have to verify my client.
ના ના જોઈ તો રહો. તમને
આ તો જોયું બરાબર
તમારા
છે.
client સુખી છે એ તમને
And
આનંદ
I'm not from that area, so I'm not able to go at all.
બહુ સુખી માણસ છે. પાછલા પગ.
કોઈ પતરાનું બાંધકામ.
I'll just.
My lord will give you. My lord will take over.
Take
the-
instruction, yes.
Yes.
The thing is that as per that, they have to be given 7 days notice,
Yes, sir. Yes, sir.
260.
Yes.
Correct, 7 days, then they have to file their representation, they have to be considered. And then
Some orders.
some demolition order, again 15 days.
Yes.
So that is the,
I'll talk to the commissioner.
yes,
All right.
that is what you are
Lordship,
thinking.
that is what
Let me
Lordship?
put it to commissioner.
Yes,
My lordship, for the matter at serial number 7, lordships have been kind enough to issue notice. My only request is direct service may be permitted.
number 7, Sompura.
Highly obliged.
Yes.
Please.
Yes,
As far as the petitioner's son is concerned, peculiar circumstances have erupted. Page 7 is the first response sheet.
no,
According
that is, we have know the facts, so let us not get into it again.
But correct. Now,
what
please
can
have the rejoinder where I have stated that as far as this download is concerned, please have page 207. I have no difficulty. Let this be verified by a forensic laboratory. From our end, we have no dispute. Page 207, paragraph 7. And paragraph 8, we've said, paragraph 7, we've given the complete details how this download has happened. May I just read my notes? Page 207, para 7.
Hmm.
It is submitted, the response number 1 has published on public platform that the response sheets of each of the candidates who have appeared in the entrance exam on 6, 8, 10, 11, 12, 13 and 15th April shall be uploaded on the website, which is jmain, nta.nic.in. And a candidate can challenge the answer key displayed there to between 19th to 21st. Accordingly, the petitioner's son had visited the official website of respondent on and on choosing the key option JEE mains session 2 answer key challenge. He was directed to website examinationservices.nic.in in which he had filled in his examination application number, date of birth and security pin issued by the respondent in the options offered, upon which the profile of the petitioner's son displayed with an option view question paper. The petitioner's son had logged in the said option, upon which he was redirected to web page number G05 so and so, wherefrom the response sheet had been downloaded, which has been produced before this honorable court at annexure. It is submitted that various candidates who have appeared in JEE main examination with the petitioner's son have also downloaded response sheets from the aforesaid website web page. And please have paragraph 8. It is emphatically denied that the document produced at annexure is manipulated, false, fabricated, edited, altered, doctored, etc. as released or otherwise. The petitioner humbly submits, reiterates that the document in annexure has been downloaded from the official website of the respondent at 7:03 hours and has not been tempered, altered, or edited document at all. The authenticity of the document is supported by the fact that download made by the petitioner's son on 7:03 AM was screen recorded, and the copy of the screen recording had been shared with the respondent authority immediately on that very day. And we've said that we have no difficulty if this can go to forensic for verification. Our complete record can go. Please have annexure E and please compare it with page 51. Page 7 is where the first response sheet starts. And page 52 is the second response sheet. Our respectful submission is that the answers have been wiped off because of some technical glitch. And please have the log which has been produced by them.
So first you logged in at 7 in the morning.
7 in the morning.
And then again you logged in at 1:50.
Then we were, in fact, our tuition sirs had verified on their own, and we were told that no, there is some problem. Therefore, I again logged in at 1:50.
No, verified on their own means they checked again.
They also checked because I am. Lodges are aware that these tuition classes would want to display the toppers on their. It is there where when I came to know that this has happened. Therefore, the second download happened. With this too, I went before. It's not that I had set time. Please have the first communication at page 111. Please have, this is of 20th April 13 at 13:38, which is just immediate to the download at 1:15. Lodges may have the time on the right hand side.
Yes, 6:53
Yes.
PM.
At 13:38. The second download is at 13:15.
Yes.
Please see that. The concerned authority, extremely urgent discrepancy in my response sheet in JEE exams, April attempt download at 2 different times. Respected sir, ma'am, with due regards, I so and so would like to bring to your notice that I have downloaded response sheet from my JEE exams of April attempt today morning at 7:03 AM and then check it with the given answers keys to NTA. I'm getting 300 out of 300 as per the provisional key given by NTA. But when I checked again my response sheet at 1:15 PM today, I got shocked to see that all questions are shown to be not answered. It is really disheartening and shocking for me and my family. Details I have given. I've shared the 2 response sheets. Please find attached here with the files enclosure. Those response sheets are there. And please have page overleaf. There also the screen recording. Your Lordship may see the trailing email, which is at 13:54. The screen recording has also gone. So that is a part of the pen drive which I have circulated before the Honorable Court. And I have requested that have this re-verified. I have no difficulty if this because neither of us nor the respondent number 1 is an expert on this issue. It's not about the examination or the marking or anything concerned to education. This is whether there is a technical glitch or not. whether my download which I am sharing with them on the screen recording, according to them, if it is tempered, I suffer the consequence. If it is not, then they'll have to come out with a way so that the year of the student is not wasted today. And please have the academic career of the child. Please have the rejoinder which I find. Absolute meritorious student. And please have page 207, para 5. It is submitted. Petitioner had a brilliant academic career. It is in the recently published results of Standard 12. Son of petitioner secured 91% of marks. In addition to this, petitioner's son was amongst the top 100 participants of phase 1 of TOSCO 22 test conducted by IIT Kanpur, and is also has secured 27th rank in the second phase of the state test. The petitioner's son has also been certified as a state level winner in the Gujarat STEM quiz, which is for science, technology, engineering, and math, conducted by Gujarat Council of Science and Technology and State of Gujarat, the copy bearer of this. Absolute meritorious student. 10th, 12th, the 10th 90%, 11th 97%, 12th 91%. And please have the logs which have been produced by them. Please have page 173. This according to them, they have monitored the screening of the student. 2 facts are undisputed. I was there on screen for 3 hours. According to their affidavit in reply.
This larger copy would be better to see because those are minute details.
Page number same. Sequence of page time sequence में समझ duration
173. 173
that may have said 50, 70.
Got it. In all,
There is no dispute. Or lots of bad questions. No dispute. I was just indicating whether it's the same. This is what the respondent has produced before Lordship, page 170 onwards. Yes. Or Lordship may have the first page in sequence. I'm trying to emphasize that there have been save and next and auto save, 2 commands which have happened.
Yes. So
Now-
this entire sheet is the petition.
According to them,
Okay.
yes, it belongs. According to them, it is of the petitioner. Two factors which come in.
Yes.
2 factors which come in, which is not disputed, that the child was on the computer or he was working on the computer for 3 hours. According to them, he has run through 90 questions. These 2 things become undisputed fact because that comes in the reply itself. Now, please have the activity. Lordship may have the 5th or the 6th activity. 1 or 3, 4,
second last column.
the 3rd last column from right.
Yes. Auto save.
Yes. Now, Lordship may see 6th auto save pachi, save and next, then 2 auto save and next.
Yes.
Save and next is the command where the answers are filled in, the student saves the answers, and next would take him to the next question. Lordship may have the this is an undisputed fact. There is a distinction between auto save and save and next. Save and next is where the answers which are selected, because there are objective and subjective answers. So objective answers, we'll have to tick one of the 4. So once I it could be A, B, C, D. I put in an answer, I fill in an answer, and I save that answer. Then I go to the next question. That is exactly activity which has been recorded. So there was an activity. It makes no fun for a meritorious student to not select an answer, but save an answer and go to the next question.
What is this?
I'm sorry.
Next column is what? Selected option.
Nil. But that is where we are having a grievance that this is completely glitched. I'm trying to say that there is no fun for a student sitting on the computer for 3 meritorious student, academic career of 90% throughout. Sitting on the computer for 3 hours taking an activity for 3 hours, running through 90 questions, he saves a response to the question without selecting an answer. This goes completely improbable. I understand out of say 75 questions which are to be answered, he may have aired in 5, 10, 15, 20. It can't be 0 or 100. Today, I'm in a situation that there is no answer, not a single answer given by a student. I would have accepted the fact that the student has miserably failed. He may not have been able to secure marks. I would have accepted, but that's on merits where their wisdom would step in. But this is a complete case of technical glitch. And technical glitches are not unknown to the computer, the digital systems. Now, we'll have, according to us, we have downloaded the first response sheet from their official website. That is screen recorded. Screen recording is shared with them. We have no difficulty because the computer is as it is. It can go to forensic to verify whether there is, according to them, the response to the petition is that the response sheet that we have produced at annexure is doctored. There is no question which has been raised till date in respect of the screen recording which we have shared with them. There is no denial to that fact. We are saying we have no difficulty, let it go, because my JEE advance is there on 4. I have to sit in the advance. The Honorable Court has permitted by an interim order to fill in the application by an order of 5/5/23. Today, the exam is on 4th. Pursuant to the fact that your lordships have put up the hearing in the vacation, the respondent number 5, the newly implemented party, they have accepted the application. They have registered, but the registration number and the other details are not disclosed. Awaiting your lordships' opinion on how your lordships look at this issue. Today, I am only persuading the Honorable Court. Let me give the exam on 4, subject to the full digital record getting verified by forensic laboratory or any other laboratory which your lordships deem it appropriate, any forensic expert. And if I am wrong, I face the consequences. In fact, in my rejoinder, it's my case that let it go to forensic. I have no difficulty. And it's not that, it's what I'm sharing today. My immediate response to them within 15 minutes was that there is some glitch. Kindly look into it. No response. In fact, since there was no response to my email, I had done with my sister's email ID. That is where they respond after 7 days. And that is why their case today is that after 7 days, we've responded to your sister's email. Therefore, where is the question? We've said, we've given what we have. And please have, with all the grievances that we've made, please have the response that they have made in the affidavit and reply. Please have page 182. Please have item 2. Kindly read this closely, because our grievance is there is a technical glitch from your basic examination server to the main server. In response of this, please have item 2. As per the record available in the database server, the scorecard of the candidate having application number so and so for session 2 is enclosed here. That's where our question is that there is a glitch in your database from your examination server. It's not that the glitch I'm just alleging in air. I understand if I did not have a response sheet at 7:03, I would have no case. I would have no material to persuade your lordship. Fortunately for the petitioner's son, not only he has got a response sheet from their official website, but that is being screen recorded, which I have shared with the Honorable Court in the pen drive with the rejoinder, saying that let that also get verified with in respect of the downloads done. For the petitioner, we have no difficulty. Our only worry is that the year of the kid should not be wasted. Absolute brilliant kid, and for no reason, he'll have to sit at home for 1 year. Because the distinction between JEE mains and JEE advance is that if he clears JEE advance with reasonable colors or reasonable marks, he steps into IITs. The kid's complete career is at stake. All that we are requesting the respondent authority take a pragmatic approach. As far as the interim arrangement is concerned, your lordships have already directed the newly implemented respondent who's taking the JEE advanced examination to accept the form. Let those registration details be released. Let me sit in the examination. Subject to have your lordships view the technical record or the digital record in next 10 days, then your lordships may take a call whether I should be permitted to take the benefit of the results which may come in JEE advance. Because if your lordships are to conclude on the basis of digital record that the records which I have submitted to the honorable court is correct, then they'll have to have an introspection and to clear my name. If my records are right, if my response sheet which I've downloaded at 7:03 is correct, and the screen recording which I've shared with the honorable courts for the honorable courts perusal is right, then they'll have to have an introspection, either to take a fresh examination, immediate examination, to entitle me for admission this year. If I miss the bus, then the year is completely wasted for the petitioner's son. All that we are persuading our lordships is that the honorable court has already made those directions. In fact, it was to await their response if some way via media could have been found out. As I see, the response of the respondent is that our database stands as it is. There is no change. Today, I am persuading our lordships that let this be verified. Let our bona fides, our record be verified. If we are right, your lordships may take a call whether to permit the petitioner's son to take advantage of the marks which he may obtain for the purposes of admission. If I'm wrong, I face the consequence, and we are aware. In fact, the petitioner is I have put him to guard that if your record is wrong, you will face prosecution.
Yes.
I've said so.
Yes.
So we are conscious of that. We have made that. Kindly have a statement on oath. Please have page 208. Yes, yes, Please have para 8 last 5 lines. In furtherance thereof, the petitioner is ready and willing to have the said screen recording as also the computer from which the said document was downloaded and whereafter has been stored, saved, to be tested by and scrutinized by the forensic scientific laboratory or any other expert agency with this honorable court may so like. So we are aware of both the consequences. If we succeed, we succeed. If we don't succeed, we are open for prosecution for producing fabricated document before your lordships. With that consciousness, we've come. So I'm only trying to persuade that if there had been a hanky-panky, we would not have been forthcoming before the honorable court to have this at our request. And as far as these kind of interim arrangements are concerned, your lordships have time and again come across the directions permitting the students to appear in the exam, subject to how your lordships finally view it. Division bench of this honorable court has taken similar views. And there's one more fact. The lordships may have the order of 5/5/2023. The respondent was died. We had to check whether we were bona fide in pursuing the honorable court for, I'm sorry, in this petition 5/5/2023 of this honorable court. The honorable court, at our instance, we had been pursuing the honorable court as a statement made in the petition in para 16 of the petition that as far as these centers are concerned, they are island centers at various places. So there is on the centralized system, there is a video recording of every movement of, it's not about the screen, but the movements of the child. That was directed by this honorable court to be produced before this honorable court. That key or the pen drive was given to us on 22nd of this month. Kindly have, in fact, we've got the recording. The student was continuously working. There have been the physical movements would go to show that he was completely active to the answer. This is their record. It is not my record. I am saying that also supports our submission that he has attempted that. He may not score 300 out of 300. That's a complete domain of the respondent. The answer key, whether I should be given 300 or 290 or 280 marks. That's completely their domain. But to say that not a single answer is made and everything is doctored, in my respectful submit, it is a little too harsh for a student like the petitioner's son, who has otherwise a brilliant record. Kindly, that video recording is there. At several places, we'll see that he has reacted to the answer. There are some answers which he could give, he immediately body gestures come in that he has been attempting or he's been active to the questions. Now to say that he has been active, he scrolled through it, he's done the activity of save and next, but not fed in an answer. In my respectful submission, is nothing but an improbable theory. It is just to cover up a technical glitch is what we see. But as far as on the issue of technical glitch, your lordships have, may kindly have one observation of this honorable court. Paragraph 12. Paragraph 12. The Honorable Court has observed that technical glitches is what you can't rule out. This is where we premise our case that kindly have an introspection of your computer or your digital system where something could have faltered. And today I have some material. I am only pursuing, I have some material to pursue your lordships in terms of the response sheet downloaded from their official website. That is one. And second is my screen recording, which would go to show that the response sheet which we produced before your lordships, that Annexure E, is not doctored as casually indicated in the reply of the respondent. That is our only request today as far as the further interim relief is concerned. Your lordships may permit me to give exams on 4th. Subject to an undertaking as the division bench has already put the petitioner that I will not take advantage, and the marks which I may obtain without your lordship's permission, I will not utilize it for the purposes of admission. That is it.
As yesterday I pointed out.
Only lordship, that visual which my senior has produced with the reply. Lordship, I mean, we've got that opticals ready.
Okay, the whole
That only
pen drive.
shows that for 3 hours he was very much
No.
there.
Yes,
That
No,
for
kindly,
3 hours very much
kindly,
there, and he was on the keyboard. Because unless he is on the keyboard with the mouse, how there can be proceeding with any question from question A to question B to question 3. So how he can proceed? Obviously he has proceeded, and every minute second, 100th part of the second is recorded. He has also visited, I have also marked it. Say
Yeah.
question number 1.
yes.
There, question number 1 is again then referred to at around 12 o'clock, the third page. Third page may be seen, the same question is referred to at 12 o'clock. So after 3 hours also he is on the same question, again back to square one. So that is also recorded, that now you have moved to again the same question. I hope, my lord, I am clear.
Yes, yes.
Yes. So
It is.
this is
See,
the
it
recording
is-
of all these 3 hours.
Question 1, 1, 2, 2, 2, 3,
Yes,
3,
ma'am.
3,
Exactly,
4, 4, 4.
exactly.
Then it comes to 11, 12, 15, 16, 17, 18, 19, 20. Then again 1, 2, 3.
Exactly.
So he's gone back to the question.
He has
again.
gone back to the question. So save and next is, I mean, that doesn't mean that he has exercised his option, because at that point of second, it has been recorded that any option exercised, answer is 0.
That is why he has gone back to it. Yes.
Yes,
That
exactly,
is one way of looking at it.
exactly. The other important aspect which I will be pointing out to the Honorable Court, that yesterday, since I had requested the Honorable Court that I am also trying to contact my client as well as NIC TCS. They have given certain details. I'm sharing those details with my learned friend, my lord, for all fairness to him. I will straightway first take the honorable court, my lord. The first email is addressed to me, my lord. We are not much concerned with that. The honorable court may kindly permit me to see page 3, which I have also produced along with my affidavit in reply. Page 3 was already produced. This is the response of NIC. That is providing technical support to NTA for G main 2023, the first sentence. As per the record available in database server, the scorecard of the candidate having application number this, name Kush so and so is enclosed as the scorecard. As per the scorecard, NTA score obtained by the candidate with respect to the application number so and so is 7.7 percentile for session 2. Details of the scorecard was shared on candidates and parents registered email on this date with NTA so and so. The final percentile and all India rank was shared on candidates and parents registered mobile on this date. As per the record available in database server, this is important, Mano. This is what NIC says, and then I will take the honorable court that what TCS has saved. Database server, details of result and answer key challenge log for application number so and so for session so and so is attached for reference. It may further be noted that the recorded responses were not shared by NIC on the candidate's email. This was not done with respect to all 11 lakh students, so we are not concerned much. Then the next is about that percentile mark sheet, NTA score, which the student got. Somewhere in the middle, total is 7.740.
That is
Now,
on page
that is on page 4. I'm sorry.
4.
That is 7.740. This is not the actual marks. This is the percentile. The honorable court, Lord, it would be my duty to point out that suppose out of 300, one person only out of 11 lakhs, suppose only one person has got 290, for example, I'm taking. Then he is said to have got 100% percentile.
Yes.
So, so the only one student has got like this. So the 7.740, this is only the percentile that these are the number of students who are similarly situated, who have not attempted any question whatsoever. That shows only percentile. How the percentile is worked out, that is also stated in my affidavit in reply. Then the honorable court may kindly see page 5. This is from TCS, Malord, to NTA so and so DG office. TCS confidential. Hi. As requested, please find attached below the observations regarding the candidate audit log of the candidate with roll number this. The candidate logged in at Wednesday, April 12, 2023 at 8:57 and 17 seconds. The candidate started the exam at this point. The candidate visited 90 questions during the exam. During the course of exam, the candidate did not select any of the options. They are the service provider, the TCS says, options for the visited questions, but clicked on save and next. Hence, his recorded response did not have any of the options. The candidate exam was submitted, that is the completion of the hours, that is on 12 hours, 1 minute, 9 seconds. Now, this is that log which is produced before the honorable court along with my affidavit in reply. First to attack is that regarding screen recording, my learned friend has tried to made out a case according to him on the basis of the screen recording. With regard to the screen recording also, we have found what we have found, your lordship. May first, my lord, permit me to refer to page 207 of the rejoinder. And 208, I will be referring paragraph 6 and 8. May I read, madam?
Yes.
It is humbly submitted that the response sheet download by the petitioner's son at 7.03 on 20th of April 23, as also the glitched response sheet that he is referring to with regard to 1 o'clock afternoon response sheet he is referring to were shared by the petitioner's son with the respondent authority on the very day by communication dated so and so hours, along with the screen recording of downloading of the said response sheet of 7.03. But this shows that according to the candidate, the same was screen recorded at that point of time, 7.03. I hope, my lord, I'm clear.
Yes.
Despite having the said record, we have not acted. This is what the allegation is. Then paragraph 8. In paragraph 8 also, what is stated? After leaving 3 lines, the petitioner humbly reiterates that the document produced at annexure E regarding that 7.04 hours download is as has been downloaded from the official website of the respondent at 7.03 hours, and it is not tempered, altered, or edited document at all. The authenticity of the document is supported by the fact that the download made by the petitioner's son at 7.03 was screen recorded. The download, he downloaded as well as video recorded according to him. That is screen recording, they call it. When one is going to his account and perusing the same, at the same time he is pushing the button regarding the screen recording. So that screen record is also said to have been done by him, and the copy of such screen recording had been also shared with the respondent so and so authority immediately on the very day. The screen recording of the download made by the petitioner's son from the official website of the respondent at 7.03. Would my lord kindly bear with this and kindly mark this, because I am hinting on it. We're putting a nail on this. A respondent at 7.03 is produced through the pen drive. So the sentence makes it clear, my lord, that the screen recording of the download made by the petitioner's son from the official website of the respondent at 7.03 is produced here with an as pen drive. Now, would my lord kindly see the last page of what I have submitted to the honorable court. This is with regard to the screen recording of the response sheet. The screen recording of the response sheet. The technical TCS, my lord, service provider, they have also examined it. That what are its properties? Not on page 11, I'm sorry, page 11. It is recording properties. So what is its properties? Meaning thereby that video came to be recorded at what time? It shows it's 20th April 307.
But my friend, I'm sorry, this is misleading the because what?
Let not interrupt.
No, I tell.
Let my learned friend not interrupt.
Unfair statements. This is not part of their pleading. In the my friend may point out one pleading that this is Dr. 1, and 2 that what my friend is showing today is the pen drive. The pen drive which my friend's reply came to us on 18. The immediate thing which we did was getting it into pen drive. The pen drive is of 24, not the original recording. And my friend, this is unfair to the petitioner. Please have page 112. It's not, my friend is completely wrong. Please have page 112.
Let him finish.
I'm
I'll listen to you again.
I'm extremely,
Listen to
I'm
you.
extremely.
But let him put up his case.
So I'm just saying, put the facts correctly. I have no dispute about if we are to fail in the petition, no difficulty. Very good. I'm extremely sorry. I'm extremely sorry. I'm extremely sorry.
But the rejoinder is concerned, the rejoinder is filed on 26th of May 2023.
Yes.
In this rejoinder, in paragraph 8, they have specifically said that
703.
703 recorded from official website at 7.03 is produced through the pen drive, and along with the rejoinder, they produced this. This was sent to NTA, to TCS for verification. They have said that this is not the recording which has been done. at 7.03 hours of the day. What they have said is that this has been done at 20th of April, same day,
3 o'clock.
at 3.07. Now the Honorable Court may kindly visualize that the student says that at 7:02, he downloaded, and that shows that he has attempted those questions, likely to get 300 out of 300 marks. But at 1 o'clock when he saw, he found that he had not attempted anything, and that's what also is downloaded and produced before the court. And this is the discrepancy, alleged discrepancy, which my learned friend is talking about with in connection with this exam. The question is that at 1 o'clock, it is nobody's case that after 1 o'clock, one could have video recorded the what he has downloaded at 7.02 hours. Then how this is doctored at 3 o'clock in the afternoon on the same day? Because this is what the property of that document shows. The property of the document shows that the media is created, the word is, the media is created on 20th of April 2023 at 3.07. So this is not the one which is recorded in the morning, because it could never have been recorded. Now, with regard to this pen drive also, MP4 they call it, what are the findings with the NTA has reached, Manoj? Then I'm coming to the Honorable Court, Manoj. That page 6 of the compilation which is given and also shown to my learned friend. My learned friend is saying that I have not put it on affidavit. I can put it on affidavit, but since we were running against time,
Yes.
yesterday I had said that let it be kept today, and therefore I am placing this on record. Now, in the first part, on the first page, paragraph, page 6, it is the case which is sought to be raised by the petitioner. Then submissions of NTA, your lordship may see, it is yesterday evening, I have received. It may be mentioned that the provisional answer key along with the question paper with the recorded responses of the candidates were displayed on the official website of GE, http gmain, for candidates to challenge prior to the declaration of the result NTA score for session 2. The question paper with the recorded responses of the candidate for session 2 was displayed to the on the website so and so from 90th April to 21st April up to 5 p.m. As per the record of the respondents, the petitioner has not answered any question in session 2 main examination. The answering respondent has got verified, cross-checked the recorded responses which exist on the record of NTA, and the one came by the petitioner from the service provider as well as NIC. Well, from the service provider is TCS,
Yes.
and also from NIC. NIC is the lordship knows the agency which keeps every record, even including the of the High Court and all courts, which provides technical support to NTA. NIC has certified that as per the record available in the database server of NIC, the scorecard having application number so and so for session number 2, that is 7.7. The recorded responses and the results of all the candidates, including the petitioner for G main so and so, have been uploaded only once on the official website. Only once it is uploaded. And whatever is downloaded, which is produced after page 53, is the only thing which is uploaded by TCS and then by NTA. No other one. Uploaded only once on the official website, hosted by NIC, and it has not been changed or modified as claimed by the petitioner. The claim of the petitioner that the NTA has not verified the data on its server is vehemently denied and devoid of any merits. It is submitted that the service provider, through its email dated 11/5, provided the following responses to the query. And they are comments on the allegation raised by the petitioner. There appears to be a technical error in syncing the record, so and so, so and so. And what is the response? Response of service provider, the Honorable Court may record. There are no error in recording candidate response. Audit log shared earlier clearly indicates candidate not attempting any question for other candidates present in the same drive as candidate. We can see their responses in audit log. So other candidates' audit log shows that they have attempted. Here the audit log shows that recording of hundredth of a second is also recorded in this audit log. This audit log is at the examination center, simultaneously recorded at TCS, service provider at Bombay. Then second, verify the backup from examination server with respect to this candidate of G mains so and so, to which the response of service provider is there is no error in syncing candidate data from venue, that is venue of examination, and the TCS data center, that is at Bombay. There is no error at all in relation to syncing also. Because the argument of my learned friend was that at examination center, whatever may be the data, it might not have been properly synced, maybe on account of technical glitch, according to him. But that is also verified, and they say that no, there is no error in syncing candidate data. Furthermore, with respect to the recorded responses also, the following has been informed by the service provider on 15/5. The candidate logged in, which I raised to the Honorable Court, that how he visited all questions, but did not select any options. It is further submitted that there are many layers of checks to verify the performance of a candidate. Therefore, there is no likelihood of any discrepancy in the evaluation system conducted by NTA, as the petitioner's responses recorded therein are electronically stored with the timestamps as audit logs. So the audit logs which we have provided, my lord, the larger copy, my lord,
Yes.
that after going through the process mentioned above, the NTA declares the result of candidate, including the petitioner, based upon their responses recorded during the conduct of the exam and final answers. It is reiterated that the recorded response sheet displayed on the official web portal, original from audit logs. A copy of such audit logs has also been provided to the petitioner during his visit to respondent's office. He also visited our office, and we provided the audit logs also to him in his presence, that this is your audit log, which clearly shows that the petitioner has not answered a single question. It is submitted that the present petition deserves to be dismissed at the outset on the ground that the petitioner has sought to set up a false case against the answering respondent, NTA. Petitioner has falsely pleaded that his recorded response sheet has been changed, which is vague, baseless, unfounded, and wrong. It is most respectfully submitted that the NTA has no personal axe to grind against the petitioner. G mains 23 has been meticulously conducted, wherein the response recorded by the candidates have been electronically stored and verified through audit logs. The recorded response sheet, which originated from audit logs, has been displayed to all candidates, and careful procedure has been followed at every stage till the declaration of results. Further, the examination has been successfully conducted in a fair and unbiased manner for 11,62,398 candidates at 457 unique examination centers in 325 cities, including 23 cities outside India as well. Therefore, there is no question of any malpractice, and the allegations made in the writ petition that are all nothing but a self-serving statement of the petitioner with a mala fide. I am not attaching much importance to this. Then paragraph 8. As far as the screen recording produced by the petitioner is concerned, that my lord, MP4.
Yes.
It is pertinent to mention that the petitioner has based his entire claims that he downloaded the claimed recorded responses on 20th April at 7:03 hours AM. However, the screen recording of the same does not provide the date and the time as alleged. The taskbar has not been covered in the recording, because generally the taskbar shows that what is the time of that MP4 recording.
Yes.
But that is also not there. Covered in the recording for the base reasons known to the petitioner. Furthermore, the screen recording does not show the cursor or the mouse movement. But movement on the screen can be made on two grounds, either by the mouse, so that the cursor will move from here and there, there is a shift also which is provided on the screen, on the basis of which also one can move from this to this, but that is reflected while doing videography. Furthermore, the screen recording does not show the cursor or the mouse movement. These specific omissions on the part of the petitioner raise serious doubts about the bona fide of the claims of the petitioner, thereby suggesting that it may have been created afterwards only to falsely portray that he has obtained higher marks. It is submitted that in order to gain undue advantage over the actual performance of the examination, the petitioner is only trying to mislead the Honorable Court by placing reliance on the doctored, forged, fabricated documents, as the same is contrary to the record maintained by the answering respondent, being the examination conducting body authorized to issue scorecards and maintain the record. It is further submitted that the petitioner is liable to be treated as UFM. This is unfair, means there are also provisions for dealing with such, and this includes the doctoring of any videography or downloading anything by doctoring is also an offense. Furthermore, it is relevant to mention that as per the norms of the examination, candidates who indulge in manipulation and fabrication of the document issued by NTA is liable to be booked under this. I'm not much laying emphasis at this juncture on this, and punishment is also provided for the student. Then page 10, my lord. It is reiterated that the copy of the recorded response is relied upon by the petitioner at annexure E of the writ petition is not on the record of NTA. It is not on the record of NTA at all. This is what we have said in terms. And the same appears to be for manipulated doctored from the original document. Thus, the claim of the petitioner, because we are providing both answer sheet, that what are the correct answers, answer 1, option C, whatever. So that correct answer sheets we are providing, that this should be the ideal answer sheet. And we also provided what you have attempted for. Now, how he must have manipulated from the one which we have supplied. The one which we have supplied is also produced from page 53 onwards. And that shows that he has not. Why? Because that is based on this log data. Log data records his activity every fraction of a second. What else could be that electronic data could be? Except this, his presence at the site is not disputed.
That is even with
Correct.
this.
Look, we have come across cases where even an intelligent person may, on a given circumstance, fabble and fumble to such an extent that he won't find out what to write, what not to write. It happens in a given case. So those cases are there, but here that he has tried to play a little more smart by creating that MP4, which is as a matter of fact created on the same day at 3.07.
So
Look
now
at the beauty.
if he has created it, he will go for that unfair means practice.
He has to go for
3
it.
years.
He has
for
to
that.
go for it. This is our finding. This is our finding, that look at this. The computer will not say anything wrong. He is saying wrong on affidavit. A wrong statement on affidavit that was this screen recording was done at 7.03. This is the statement which I read from paragraph 8 of the affidavit in reply, this affidavit in rejoinder. Now, on the face of it, when the TCS said that look at this, the MP4 which you have provided, because I sent it to the NTA sent it to the NIC as well as both to TCS. And they said that look at this, the recording properties of this MP4 itself shows that it is recorded at 3.07, not at 7 o'clock in the morning. Then the question is that how this could have been done at 3 o'clock.
Because the second is
Second download
is at
second download is at 1 o'clock prefer, I think so.
1:15.
That is at 1:15. Second download is at 1:15. And after that point in time, according to the petitioner also, there is no other recording available. After 1:15, I hope I am clear what I want to convey. That he came to know that, oh, at 1:15, when I saw, it shows that I have not answered anything. So I am shocked. But that is 1 point, at our 1.15,
Yes,
meaning thereby after 1.15 hours on that day, assuming there was no other answer available from NIA,
yes,
NTA,
yes.
and then how this recording could have been done? I am putting a question to myself. If they say that this is screen recording at 7 hours in the morning, then this could not have been there at all. They have supplied this on record, and it shows that this is something which is totally a created thing. And that is why it doesn't show the upper part of the computer as well as the lower part.
No, now the thing would be,
Yes,
at 1:15, he knows that his answer sheet is blank.
correct.
Okay. Can he at 3 o'clock
Yes.
change the answer?
No, that is the issue. That is precisely what I am submitting to the Honorable Court. That after this hour, there was no question. I mean, what we uploaded on 19th, Manoj.
No.
Manoj, this is what we uploaded on 19th.
As per this, you say that the media was created on,
On 20th of
At 3
April,
o'clock.
on the
At
same
3
day at 3 o'clock.
yes.
Hmm.
So at 3 o'clock, if a media was created and he has,
He is created by
Yeah.
doctoring with the computer, playing with the computer.
but then,
But his computer, his laptop from which he produced this MP4 recording, is that recording is done in his computer at 3 hours, at 3 hours. Well, this answer sheets we produced on the site on 19th. It is valid from 19th to 21st.
yes,
We say that on 19th also, we say that on 19th to 21st, what we uploaded is the same and same one answer sheet beginning from page 53 onwards. We never uploaded page 7 to 51.
so you, basically you were saying that at 3 o'clock,
Yes,
the answer sheet was doctored.
Ah.
It was,
that MP4 was made
My-
video record, screen recording. How there could have been a screen recording at 3 p.m. I'm putting a loud question to my mind, Mano, that he could not have. Screen recording could not have been done at 3 p.m. That is the last nail in the total scenario. Because according to us, from 19th to 21st, we gave also the answer sheet, that what could be the answers. And we also supplied the answer sheet of the candidate. That this is what your response sheet, they call it. No?
what does the MP4 show?
Yes, this MP4 shows that morning hours, 7 o'clock recording,
The time is not shown.
time is not showing, date is not shown, this MP4. The MP4 do not show the lower bar, upper bar, nothing.
Taskbar is not shown.
The simple submission to the Honorable Court would be, you know, that when we say that NTA has only published one answer, so far as the recorded response of the candidate is concerned, from 19th to 21st, it is the same which has been supplied by the service provider. It has been the same which has been also confirmed by this NIC, that yes, this is the only answer of the candidate which we have supplied you, NTA, and NTA has put it on the site. He managed to get it after, once the answer sheet is given, that true answers are given. One can manage with, if one is technically expert, one can manage with those things. With any candidates.
Then he,
No,
otherwise is, no, in a lighter way, if he can doctor this within few minutes, then he's otherwise.
No, otherwise mathematics is something different.
Yes, correct.
And technical knowledge of this
Correct.
doctoring is something different. I am only putting this question before the Honorable Court, that now kindly see my affidavit in reply. More particularly paragraph 3. So, my lord, this 11 pages compilation which I have given to the Honorable Court with all fairness to the Honorable Court as well as to my learned friend. This shows in substance that how the things went on. Maybe, I mean, he might have been under depression or whatever is there, my lord. We are not scanning that in his mind. The fact remains that the service provider also said that what is recorded from second to second and fraction of second to fraction of second is the log. This log we supplied to them. Along with the petition, it is not there, but we produced it. And we also said that this was supplied to the candidate and his relative when they came to Delhi to point out that, look, this is your log. What can be done? You have not attempted. What has gone wrong is a different proposition, but the fact remains that what is recorded at the examination site is transferred to the TCS Bombay, and based on that total evaluation is done by the service provider, and then it is sent to the NTA for the purpose of giving marks, because every question will have to be marked like this one, or if it is correct answer then 4 marks, if it is incorrect answer then negative marking of 2 marks, something like that. But here no marking because no options exercised. Now, in my affidavit in reply, kindly permit me to go to page 114, paragraph 3. The second part of paragraph 3, the petitioner has rested his claim on the eligibility of the candidate to appear in G Advanced 2023 examination conducted by the respondent number 1 on the premise that he attempted all questions correctly in G session 2. Session 2 was this 9 to 12 and ought to have scored 300 out of 300 on the basis of annexure E, which appears to be manipulated as it is not as per the record of NTA. As per the record, the candidate has not recorded any response against any question during his examination on 12/4/23 in shift 1, and on evaluation his result has been declared as so and so, NTA scored this only in physics so and so. The cutoff for qualifying the G Advanced Examination 23, would my lord kindly mark? The cutoff for qualifying the G Advanced Examination 2023 was declared as 90.77 percentile. He is not eligible for appearing in the examination at all. He is not eligible. The cutoff percentile is 90.77. My learned friend wants the Honorable Court to believe that maybe I might get less marks, but I have attempted questions. Is there any evidence? Answer is no, because the call log, log sheet clearly shows that he has not attempted. On the face of it, still the submission to the Honorable Court is that he should be allowed to appear in the examination. The qualifying marks, the eligibility marks is 90.77 percentile. All students above 90.77 percentile can only appear at the examination. And that is the reason, my lord, this apprehension was pointed out to the Honorable Court, my lord, the previous court. And therefore, the court has stated that this is only subject to, I am permitting him to make application, but this is subject to the further hearing, and no equity is created by this.
As per this, the first annexure
Yes, ma'am.
at E,
Yes.
what according to the petitioner, it
Yes.
was downloaded on 7.
Hmm.
What are his marks?
What? I'm sorry.
What marks has he secured in this?
What marks?
Yes, this,
That I think preferably he will, because
can you,
no, I have studied of my own. I have
Page
studied of my
111.
own.
It's not my statement, please, page 111, that those, our assessment is already there with the answer key,
that is your 300 out of
300. This is up, it
But
is based on
again-
provisional answer key,
again, that is,
subject to
if
it
you
being
see
correct.
this, if you
Yes.
see this, it appears that he has gone back quite often to the,
The reason is there are, out of 90, we only have to attempt 75, the best 75 of the lot.
But
There
you
are-
have gone on the same questions back.
If you see,
May I just only to wipe off the impression which has been created by, I'm sorry, I got a little, please have the, first is, these documents could not have been given to the court in this manner if this plea is not in the affidavit and reply. Affidavit and reply, not a single averment is there questioning the screen recording. But be as it may, please have.
Screen recording is produced in the rejoinder.
No.
And not in the petition. It is not produced.
I will show,
It
I
is
will
not
show,
produced.
I will show, I will show. I show the pleading in the petition and the documents. Please have page 11 of my senior, learned seniors, the loose papers given by me. I just take his plea as it is and I try to break up. According to my senior, learned senior, two things happen at about 3. The document at annexure is doctored or fabricated after realizing that there is a 0 answer. It is, I'm taking out around 3. Now please have page 111 of my petition. Please have the time of the email.
it is 6 in the evening.
No, it's 1:38 in the afternoon. Please have right hand side 20th April 13:38. The doctoring according to the respondent is at about 3 a.m. That is 15 hours. I have shared both the answer response sheets with them at 1:38. How is that possible? I'm still it's not that I'm pleading it today. It's not that it's my plea today that I am right. The immediate response at 1:15, I received the second response. 1:38, immediately we email it to them that there is something wrong into it. Please look into it. If the doctoring of this document is at about 3 as contended by the respondent, this email is forged then. Email can't go at 1:38 for a doctored document at 3:07. That is one. Second is my learned senior does indicate that there is nothing in the petition to talk about the screen recording. Lordship may have the plea in the petition itself. These have the averments. Paragraph 11.
Yes.
Immediately, the petitioner approached respondent number 1 authority on its registered email on 24, pointing out the discrepancy in downloading sheets at 2 different times. By the second email, which was timed at 15:54, screen recording of the petitioner's son logging and downloading the response sheet at 7:03 am was also sent to the respondent number. And please have page 112, that is that email. So it is incorrect to say that it was not a part of the petition. Please have page 112. The email is there. Sharing this screen recording with them. Please have the second part of the email. It is by Khush Patel at jemain@nta. So it's incorrect to say that it comes by way of a rejoinder for the
No,
first.
this is at 15:54.
Yes, the second email, the first email which I had shared with them was 13:38 with the documents.
First
This
email
MP4 is never shared. This
Hmm?
MP4 is not shared.
My senior
One-
friend may
at page 111, it
Yes.
says that 2 attachments, response
Yes.
sheet 1 and response sheet 2. Please find the
7 AM and 1 PM.
7 and 1.
correct. Now,
That's it.
great sir. Page sub 112 જુઓ અને screen recording of response sheet MP4.
કોને મોકલ્યું છે તમે?
અરે sir.
હિમાંશુ સરને મોકલ્યું છે.
Ah.
No, it is not received.
અરે,
It is not received.
I mean, this becomes very difficult. No, but where is that averment in the reply?
પણ એ
Disputing
તમે
this.
ક્યારે મોકલ્યું છે? જુઓ ને સાહેબ કેટલા વાગે વાંચો. ત્રણ ચોપરે મોકલ્યું છે.
I'm saying, where is that?
ત્રણ ચોપરે મોકલ્યું છે કેમ કે this has been created at 3-7.
So where do I get?
3 ને 7 ક્રિએટ કર્યું છે અને 3 ને ચોપરે મોકલ્યું.
I'm only my senior may, I'm just only pointing out it is a part of my petition that has not been denied. That's the only point I'm resting my senior's contention is that the document at annexuary is doctored somewhere around 3 o'clock. I'm pointing out at 1:38, I had shared this document with the respondent authority. My senior, therefore I read the plea in my rejoinder indicating that screen recording was shared with them. It's never been questioned till this point of time, till the contention come before your lordships on the basis of some details given by TCS, which we are not able to match today because for want of any other particulars. And kindly have the bona fide, if I have doctored something, if I have forged something, would I go back to them immediately pointing out these details and come before your lordships inviting a forensic scrutiny? It's my pleading in the rejoinder that if they have any dispute over it, let it go to the forensic laboratory. I have no difficulty. I'm aware of the consequences which I'll face if I'm wrong. The petitioner is made aware about it. And they stand by their statement that what the response sheet at 703 is the actual what we have downloaded from their website. Second, my senior does indicate that the child could have gone blank. He would have done nothing. Kindly have their own video recording which they have produced before your lordships pursuant to the order of this honorable court. Your lordships would see the child scribbling on the mathematic answers. He'll be scribbling on the pages and turning the scribbled pages. That can't be, it's their own video recording. So it's not that I have produced before the honorable court. It's their own pen drive, it's their own recording which is before this honorable court. It shows that the child is actually working on the answers. So to say that he has ran through 900, because if I have not, my seniors, learned seniors assertion that the child could have gone blank. He could have got completely stunned with the in the examination. Then that body gesture would be clear in the video record. I'm saying the video recording is there. It is produced by them pursuant to the directions of this honorable lordships. Have a look at that video recording and evaluate what the contention has been put by the respondent before your lordships today. We are relying upon that video recording today. This is at the examination center, which only reflects what the child is doing from a distance. The screen can't be seen, it's quite obvious, but the child's gesture while doing activities on the question paper does indicate that he was completely active. So to say that no, he was completely stunned, he would not have answered a single question, then why would a child sit there for 3 hours?
Two issues here. One
Yes,
is that as per DC of the respondents, that the sheet downloaded at 7:03 and the screen recording both are doctored.
That's their plea.
Okay. So that one issue has to be decided by some independent agency.
No dispute, no dispute.
Maybe you can suggest where we can send it to.
Government, the forensic laboratory state
Next
of
is that the
examination on court.
examination on the 4th. Now he has filled in the
Yes.
forms
Yes.
as per this thing. But
He is not eligible at all.
But if
it's
I'm,
not eligible.
if I'm right, no,
But then there is no answer to this log sheet. The log sheet records every moment, showing that how he has come back to the same question. Even at 12 o'clock, when he is going to surrender the paper. At 12 hours also, he is not sure about his answer again, meaning thereby he has gone to question number 1 again. I have only tried to point out that, meaning thereby in the first instance at 9 o'clock, he had not opted for anything. He had not made any selection of the answer at that point of time. Option is not exercised, and that is recorded straight there and then by the electronic devices. Beyond electronic devices, what else could be there?
only one request, just not to interrupt. I've just taken those instructions. 1, 2, 3. One reason it goes back and forth because there were 4 question papers.
No, I am aware about, but I have marked also. I have marked also.
I don't know. That's not
So do you
supplied
want
to
to
me.
point out? At least I also point out to my learned friend.
We are also taken by surprise with all this last minute circulation. But Lakshis,
No, that is here, no? It is,
Yes, that is also produced.
it is produced here.
This expanded version is given only with a view to show, my lord. That's why I not saying I is more.
Where is it here in
Lordship, I have page 170 onwards.
170? Yeah. So if you see page 170
Yes, my lord.
onwards,
No, may I point out to him, my lord, so that
yes,
he will be. It starts. Not applicable, not.
You see immediately.
He's very smart
Yes.
person, there's no doubt about it. From that bigger perspective, I think, look at this, answer one, where is that? Section 3, not applicable. Question 1, section 3. Correct?
that is candidate status.
Yes, after that,
Yes.
your
Section
lordship,
3,
is
question 1,
question 1,
section 3, question
section 3. Auto save, you said, correct?
No, but auto save
No.
is not our answer.
No, correct.
The next is our answer, that is save and next. There is a difference
Correct,
between auto save and
Correct,
text.
but I will also show
Correct,
that
correct.
also.
Yes, yes, sir.
So section 3, question 2, it's mentioned, correct?
One.
No, 1 to ache upar.
Niche par one.
1 che, then again 2, correct? Now, see this, save and next, auto save,
Correct.
and now see the last page. At 12 hours, what happened? Section 3, question 1. Last 3 things, the Honorable Court may kindly see, my lord. Section 3, question 1. At 10.1 point so and so, at what hours? At 12.1, 12.01, the third column shows. Wednesday, April 12, 12:01
The save and next.
bar
Save and
1 minute 9 second. So now what I want to convey is that again section 3 question 1 is
Not
approached.
No,
Approached.
exactly.
Again approached by you.
Then
But you are not answering what can be done.
complete theory. I'm sorry.
No, you might be thinking complete theory, but so far as electronic record is concerned, it is recorded for 11,40,000 students. This is recorded, not for one student.
So my
I have no edge to grinds, but this NTA has no edge to grinds against petitioner.
never made
This is the recorded. This is the recorded thing. Computer has recorded.
Correct.
Who else can be a
only
wiser person?
kindly accept what my senior friend says. Please have page 170. My senior friend reads this, that at 90149, question 3, section 3,
question
1, auto save, so there is no activity from my end. Then at 90213, the activity is save and next for section 3, question 1. That is where I have attempted. Lordship may notice.
Yes.
There's a difference. Auto save and auto save is not any response by me. Save and next is a response by me. And now please page have 177. Is the answer change or is there
When
any?
a person visits one question to second question, it is auto save. My learned friend is aware about that. It is auto save. Whatever is done earlier is auto save.
No.
You have not selected any option.
Lordship may have their own.
That is the column. Second last column, selected option ID. Second last column. Every page.
The innuendo which is tried to be put by indicating no, but he's gone back to the same question. Now, the child can certainly go back to the question what he's answered. If he's wrong, he's wrong. I mean, if you complete the paper, what is the harm? And it's not that he's changed the answer. It is the activities auto save. It's not that he's gone back and saved the answer or he's changed the answer.
Then if you see selected option
Yes, my lord.
ID, then it says 0.
So that's where
Zero.
the contention of technique.
Not given, not given, not
No.
given.
3 hours, not a single answer. Not a single. I'm only saying had it come to against us that we've attempted, say, 50% of the questions. I'm saying 10 answers. Not a single answer. I'm only on the probability of the child sitting. There is a video recording which shows that he's scribbling the answers on his rough page. And he's attempt the save and next is not a auto or a generated thing from the computer. It is save and next would be a activity done by the child. So if he sits there for 3 hours and not answering a single question, in my respectful subject, is completely improbable. Absolute improbable. I'm saying that there has to be some glitch that the answers are wiped off. And my learned senior indicating that a child may get stunned. Please have his recent performances also. In this very subject, please have page 215. This very subjects. He scored, he was the state topper. State level winner. Please have page 215. These very subjects.
Well, an identical issue also came
Because-
before another high court.
No, but there I show that it is materially different. Please have page 215. This is the government of Gujarat taken examination for science, technology, engineering, and math. And please have the fourth line. He's a state level winner. To say that such an academically brilliant child I would have accepted the response that the answers are wrong. Say out of 75 questions, he's only attempted 15 questions and left the other 60 questions. I would have accepted it. But to say that the child was sitting there for 3 hours doing nothing, despite the fact that now there is some evidence to show that he was attempting something without, now I don't understand the fun of a child undertaking the exercise of saving something without filling in an answer for not for one question, for all 75 or 80 questions. Completely, I'm only on improbability. Therefore, I'm trying to persuade the Honorable Court that there has to be some glitch which has happened that the complete answers are right now. I have no allegation against the respondent of their doctoring or their doing anything. That's not the contention which I have made in the petition or the rejoinder. All that we are
But that is not the.
I'm saying
Candidates, my lord.
and second is second.
Because
This
they
is all
don't have any
electronically
personal
recorded device.
evidence against
Electronic
you.
Therefore, I said that it's not even my case. Some people have done it, but we have, in our wisdom, we have not, because we are aware that it's not
Some
manually
people
done.
have done it.
Some other courts, yes. My senior friend is relying upon a
I'm
judgment.
relying upon a
Yes.
different judgment, but that's.
But correct, but their allegations were made, but I'm saying I understand that this is a digitally operated examination,
But
which
in relation-
where humans would have
Let me
had
understand.
control in that sense. I'm accepting, I'm putting to their, I'm saying that I'm not putting any allegations of malafide against them. The only limited submission is, according to us, you actually would have noticed in our rejoinder, the only grievance which we have, that when we point out the technical glitches, you should have introspected into what your record stands. That's the only submission that we've put up. Second, that my friend's theory that the documented annexure E is doctored at about 3 is completely nullified by the fact that the email was sent by us to them at 13:38, and that sending of both the emails is not disputed. Lakshmi may have the pleading in the reply, not a single ever made, denying that this email was sent. Specifically, the 2 emails were sent by us, and neither of them, and there is not a single comment in the reply in respect of the screen record. I will point out.
My friend has finished for like that.
Therefore, the respectful submission is to
Now, as far as eligibility is concerned, as per your first, suppose we go by that,
then I'm eligible.
you are eligible that 9.90 point something percent.
No, I'm 300, so I'll be with the first rank. If I'm right, I'll be the first rank.
Yes, and in case it goes for
It-
by the forensic science laboratory or something, then you face a lot of
Correct, we are aware about it.
your career will only go.
No, not only the
that
career,
you-
prosecution, yes.
Prosecution, criminal prosecution, you are at a great loss. Better make it very clear. You want to take 5 minutes, you can let that sink in. You can take 5
Well-
minutes and ask, because in case,
No, I'm aware about it.
in case something has gone,
No,
you know,
Even if forensic, my pleading is wrong. In the rejoinder, we made that positive pleading. So I am conscious about the consequences which the father would bear on the basis of fabricated document.
the only thing is that here he has come with a case that I have at 7 o'clock, I have downloaded the answer sheet,
Correct.
which shows that some, I've not gone into how many questions are right or how
because
many questions are
That
wrong.
was done a day before. As a matter of fact, we uploaded the
On the
correct
19th,
answers on 19th.
yes,
It was open all throughout up to 21st. It is
Yes.
nobody's case that on 19th I had not, uploaded
yes,
all the candidates' results. All candidates' results of all 11,40,000 students were uploaded.
yes,
What we have said that we have not changed any uploading.
yes.
Whatever is done on 19th is the same on 20th at 1 o'clock also and on 21st also.
Yes,
So on 20th, if at 1 o'clock, if he has downloaded and found that what is uploaded by NTA is a particular answers in which he has not, attempted at all any questions, his answer sheet, the candidates' answers, then how there can be a video recording at 3 o'clock, at 3 p.m. How there can be a video recording? Because at 3 o'clock or at 1 o'clock, it was the other thing which was already uploaded. Then how later on he could have made a copy of something else at 7 a.m. It is inherently improbable.
Exactly what, whether is it possible, because the questions are there on the website. Okay?
Yes,
So you go into your account.
Correct.
Your number you put, so
Very
they
true.
come there.
very true.
Now,
So
can
he could have gone on 19th on the same website. He could have seen that, yes, this is the position. Then on the basis of answers which we have provided on 19th, he will say, he will correct it manually and would download it. One can download it. See, our answers, what we have uploaded on 19th is also supported by TCS, NIC, that it is the same which we have forwarded to NTA. They are the service provider and they say that what is recorded at the site, that is at the examination center, has been transmitted to the Bombay head office also. And that is ultimately sent to TCS and NIC.
Yes.
And NTA, because NTA then assess that what are the marks to be given and what the mark sheet is to be prepared by the NTA. Now, with this log, what else could be the marks which can even imaginary confer him any eligibility criteria? He is not at all falling in eligibility criteria. We might have any sympathy for him, or he might be intelligent in 12th, he might be intelligent performing somewhere else. I am not against him. But the fact remains that against this call log, how one can think anything beyond it? Because it has recorded every movement of the candidate, every movement. And that is what precisely I have stated in my affidavit. Kindly turn to me, my lord, with me on my affidavit, paragraph 13. Similar thing, my lord, happened in relation to our NEET examination for the purposes of medical admission. And the learned single judge of the Madras High Court at relevant point of time said that you appear in the examination. You fill in the form, appear in the examination. He appeared in the examination, he cleared that examination, though he was not eligible. Thereafter, we carried the matter to the higher forum, then also to the apex court. And the apex court said that the learned judge should decide on merits that whether he is eligible or not.
Yes. So we still.
What happened? What happened was this, that after 3 years, the students who studied for 3 years in medicine, his counsel also argued that, sir, look at the performance in medicine. All 3 years I have succeeded with colorful results, bright results, plus 70% results. But the court said that nothing doing. When you applied, you were ineligible. Though application was allowed by the honorable court, you are uneligible, and you have created a particular document, which I am showing on the face of it, that his creation, his fabrication or doctoring of a document, to say in a better words, this is the creation. Against creation, no equity can be there. We have all sympathy for him, but he has failed. And against eligibility, why the court? So in that case, after 3 years,
have 2 days.
3 years, his admission is cancelled. But no, I can place all these facts also on affidavit also.
Do it tomorrow.
Correct, I'll
Do it tomorrow.
But
I'll do it
Tomorrow.
on forensic, I have instructions, lordships were directed today itself. Let the forensic,
We'll let him come with that.
then the problem is I'll have to meet with it. I'll have to meet. I have got a different version than what is
Yes.
oral.
Now
but-
you have these documents also, what he has come up with.
Yes, correct. But,
Yes.
but
Yes.
with this sheet, it
We
will be
still-
impossible
wait,
to
We
what.
still have today's 31st, right?
Yes, ma'am.
We'll come back tomorrow.
Yes.
No, I'm only in the meantime, there is suggestion which will end the controversy, whether I am right or my learned senior is right. Lordships may direct the original computer to be sent and the video recording to be sent to the forensic. Let the forensic look into it and come back to your Lordships by next 2 days. If I'm wrong, I'm wrong. I face the music. If I'm wrong, your Lordships have invested time on hearing both of us. If I'm wrong, I face.
Forensic department will be that possible.
Yes.
Then the problem today is, as far as my friends, this one sheet is concerned, it will be impossible for me to defend. How do I
No, I
defend
have
some?
no difficulty in, hoping anything.
I'm only saying
But then
there are two
whether FSL will be in a position to do within 2 days or not.
under your Lordship's directions, I'm only saying I'm running against time because the examination is on 4th.
That
If
is
I
why
miss
I'm
that-
saying we are
But
keeping it
then
tomorrow.
with this facts coming in,
If MP4
Sir,
can be
it can
sent
take
it
a-
to
I-
FSL according to my learning.
I am
friend,
saying
and if they
MP4
are in a position to reply along with this document.
I have no
Because
difficulty.
they have to compare it also.
Yes,
They can't
and
do
it
abruptly.
is not just one thing, because it has to be this, that,
Exactly.
everything.
No,
The entire thing has to go. No,
I have no from our.
his computer, wherever he has downloaded the screen recording has done.
No, I have no
So it is
difficulty.
not that is something that will, just.
So I'm
go
saying
back
if
and come back.
my document which is downloaded at 703 is fabricated, the complete thing ends here. Because then it's the only limited issue which a Lordship would consider is what to do with the petitioner. But if I am right that the download which I'm
We
sharing,
still have tomorrow, no? Later.
I'm only saying that Lordships were directed today so that at least something, if something can worked out in next 2 days,
But it's not, I can't do it in part.
everything can go. I have no difficulty. Everything can go from our end. There is no difficulty at all.
Again, they will say, where is this original?
No, I have got the original computer. They have, once we moved your Lordships, the computer is put aside. So we are not using the computer now till your Lordships one way or other opines on the issue.
Today
The
is
computer is, it's not, I'm not sharing the MP3 only. I'm sharing the whole computer where it is downloaded. I'm not, my averments are there that the computer on which the downloading activity is done and where the document is saved. We are ready to send that computer to the FSL. We have no difficulty. Because that would carry up, that would it would also have its log to show how the downloading and everything has happened. So we have no difficulty if the whole computer is taken for analysis. There's no problem from our problem is what my senior friend says that this is a document at 307. How do I go and undo this? Because this is their analysis, which we are not aware what they have done. How do I even meet with that contention? Either my screen recording and the first email, the first screen response sheet is fabricated. Whether it's fabricated or not, it's not even their domain because they are an examination body. This has to be done by
No, they have come with the record that they have.
But this is the only record on the screen recording that they have come.
Because you supplied that MP4 to us, that it has been recorded at 7 hours.
Well, Lordships have seen.
We found the properties, no, this MP4 is created at 3 hours
But
in the afternoon.
my senior friend may show
So-
one line in the reply which
But
which-
reply,
but Ajay,
that
nothing,
is
sir.
produced with the rejoinder, my dear, you
Nothing,
should
sir.
know.
I've shown this is a pleading in the petition. The annexure is there.
In the
It's not-
rejoinder, it is specifically pleaded that it is recorded, screen recording is done at 7:03 hours, 7:03 minutes.
I'm saying
7 hours in the morning, early morning, 7 hours and 3 minutes in the morning. That is specifically stated on oath. I am showing this that the property of that MP4 shows,
My friend,
and that can be looked at by my learned friend also.
but I'm just saying
That with regard to that MP4, if we click, my lord, then it will show that the properties of this MP4, that it was created on this hour. He can see right now.
I am offering.
I have seen it personally.
I am offering my computer for forensic
I
level.
have seen it personally from MP4 itself. From that MP4, when we play it, my lord, then one has to click it. And then the properties, in properties.
come, yes.
So in properties, your lordship would find this. That this MP4 is done. So even you can see it.
Let the
Why
forensic.
don't you check it?
I have
Why
checked
don't-
it, madam.
Because see,
I have
you are
checked it.
coming on behalf of him. You check it.
I
You want, let me finish a little bit more. Till then you can go. and
I
check
just
it.
re-verify.
Yes.
Because this, had
Because
this,
yes, what he's saying, it will,
exactly, you go in
properties,
property
you
and then
will see.
property, this will.
We had expected the respondent to come this in the reply. I would have met it on my reply.
There is
Not a single ever.
MP4 in I had no MP4.
We're running against time.
I'll inquire again
And
with,
that fourth is there, which
that's where
that
we're running
we are
against.
running against time. So let us see.
Once I pass it over, I'll
Yes, come
again
back.
take instruction.
Bhavnagar, yes, what happened?
No, I have talked to municipal commissioner. He says that we'll grant 15 days time to submit reply to no notice. Thereafter, we'll pass an order and further 15 days time will be granted for eviction.
As per the
Provisions of.
provisions of
GPMC.
the law.
And officers are present. My statement is on the basis of telephonic instruction from municipal commissioner. My lord will note it with respect.
Yes. Two petitions,
Yes.
Bhavnagar, na? By way of these petitions under Article 2 to 6 of the Constitution of India, the petitioners have approached the court for the following reliefs. 1, 2, 3, 4, 5, whatever it is. Next paragraph. Learned advocate, Mr.
Yes, sir, I am for it.
Mr. H.S. Munti
Yes, sir. Yes.
has appeared for the
Respondent.
respondent number 2 and 3.
2 and 3.
His wakalatnama may be permitted to be taken on record. Next paragraph. The petitioners have challenged the notice dated 23/5/2023 and the order to remove the illegal construction dated 26/5/2023. And it is the submission of the learned advocate for the petitioners that the respondent number 2
Yes, 2 and 3.
respondent number 2 and 3 have not followed the provisions of the GPMC Act, section 260
1 and 2.
into bracket 1. And sufficient time has not been granted to the petitioners to respond to the notices. And straight away, the order to remove the illegal construction has been passed. Next paragraph. The officers of the Bhavnagar Municipal Corporation
Yes, I am present.
who are present here.
Yes, I'll get the names from you.
Huh?
Names and
Yes,
designations.
so and so are present. And learned advocate for the respondent numbers 2 and 3 has submitted that you are on for the 1.
One.
Okay, so and so appears for respondent number 1. Have stated that the respondents are willing to
My lord may say with respect that I have discussed with the municipal commissioner. That is vitally important. He is the final authority. That is.
Mr. Munshi
Telephonically, I have discussed.
discussed with the give his name
Yes, my lord.
with the officers and
I-
they are ready and willing to
Yes, my lord. To grant 15 days time to submit reply to the notice.
grant 15 days time to the petitioners to
Reply to the
submit their reply to the notice
And thereafter orders will be passed and further 15 days will be granted.
and necessary orders will be passed.
And
Give them an
further 15 days time
opportunity
will
of
be
hearing also. Give them an opportunity of hearing
But then
also.
my lord may say to one of the representatives, because there are
Yes,
perhaps 100 persons, as he says, it would be difficult. So
Yeah.
1 or 2 persons may go and represent the case before the commissioner.
Legally, some lawyer may go and then.
Whatever.
yes. And give a representative or a lawyer of the petitioners an opportunity of hearing and thereafter pass orders.
My lord, that let there be a direction so far as hearing to representative or the advocate is concerned. My statement is that we'll
No
grant time.
adjournments will be granted to the
Yes.
for hearing.
But let there be a direction from the court that a representative or the advocate be heard, so that they can represent their case
Representative
properly.
or an advocate be
But
heard
my statement is only for 15 days time limit.
and 15 days time will be granted. Or as per law, because that is what the
Yes.
statute says, no? As per law, the sufficient time will be granted. Learned advocate for the petitioners also submit that no adjournments will be sought for.
Yes, ma'am.
Because what happens is once you give an
Then
opportunity of hearing, you give one,
adjournment
yes,
and bills.
and they will fully cooperate with the respondent numbers 2 and 3 in the matter.
Okay.
Next paragraph. Do not press for the petitions. Read this one.
Public.
In view of the aforesaid submission, the learned advocate for the petitioners do not press for the present petitions at this stage. And the petitions stand disposed of.
Public.
Lordships have stated that after order 15 days, they will provide. That is also recorded.
After the order,
15 days.
15 days time will be granted.
Please, come on.
Public. Highly public.
Petitions stand disposed of accordingly.
I'll give the names. Public.
Yes,
Stage it.
both matters disposed.
Yes, sir. Okay.
These are those tender matters.
14, 15, 16, I think that
Lordships
together.
Lordships may have 15 in hand files. SCA 9245 of 2023
9245.
of 2020.
Hmm.
But before
What
I
about 14? Who is for 14?
plus 14, Mr.
14 is here, 15 is here, and 16 is also
16.
here. Who is for the respondents?
But they have been served. We have filed the direct service affidavit also in the morning, Lordships. So, although the board
Yes,
reflects
affidavit
it,
not
although
filed.
the board reflects my lords, we have filed it in the morning. It is
Today morning,
today morning, Lordships.
right? Anyone has appeared?
It was a non-working Saturday, so we had to serve it on Monday yesterday, and we have called for the affidavit.
But these are the
Notice has been already served and we have got the signature of the concerned officer also. My lord.
Yes,
But
it is better if some person.
tender
appears.
Notice served and tenders are going to open on.
therefore, my lords, the request was made to keep it
No, no.
before. But my only anxiety is, my lords, that the tender provides for clarification clause. I have put in a communication to clarify the clause. They are not clarifying the clause. In the eventuality, my lords, they interpret the clause that I will be blacklisted. My 2 to 3 years tenders will be gone, my lords. Not only this one. I will not be only disqualified from this tender, my lords. I will be
Let
disqualified.
them appear. You are,
But
this
then-
morning you are filing an affidavit.
Yes,
It is a
because-
closed Saturday.
My lord,
They have
Where
been-
the-
notice served and we have got it.
Yeah.
We have got the stamp also, officer.
But
So it is their duty to remain present before the High Court.
Appear, this is what PGVC, who normally appears?
Yes. There is a panel.
Salman, काले के पूछे. We'll keep it tomorrow. You
Please.
please
My lord.
ask him to. Yes.
Since I am coming from Rajkot,
Oh,
if it is convenient to your lordship. Signature સાથે બધું છે સાહેબ.
નહીં પણ
ચાલે
જો
રાખે.
એમને સાંભળ્યા વગર I will not pass any
My lord, only notice is
Stay
required to be
operating.
served, my lord.
notice served, yes, but
If they are,
We'll keep it
if they remain absent, my lord,
we
if they remain absent, if they remain absent,
You
in-
filed it this morning. Here it says direct service not filed. Now this morning you are coming and we'll keep it on second otherwise. I don't mind.
But second, there will be a situation whereby, my lords, if anything can be worked out at all.
No,
just-
they will come here in the morning. He's taken instructions to.
With all due respect, they have been served on 29th Monday.
It's
Today
only
we are on 31st Wednesday.
and signature and date has been there, my lord. Signature and date is there, please, if permitted, my lord.
આવી ગયું છે પેલું નીચેથી?
It is there, my lord.
Okay, we'll take it, but after 10 minutes. Let me finish the other
Lord.
one. See if you can contact me. Yes, okay, next. પાસાનું છે. Hmm.
Number 17, there's a 927 of 23, this guy, this one.
Hmm.
Forward the communication from all which can be. Is this communication? In view of the written communication, I may be permitted to.
Withdraw. Okay. Okay. The petitioner, learned GP has submitted the written communications. from all the three, from Shapar Police Station, Mangrove Police Station, and Malviya Nagar Police Station. In view of the above, learned advocate for the petitioners seeks permission to withdraw. Granted, matter is disposed of. Yes.
Yeah, that is number 3. Paper 9222 remove the way
As far as respondents are concerned, I have taken sense of that. The proposal from their end is this was that sentence can be reduced insofar as the sentence is concerned, it can be reduced for a period under. Subject to, he may deposit the amount before the court towards my loss, or he may pay the loss to me, and he may give an undertaking that he'll comply with the Exhibit 5 order that is already passed. And that is admitted position, he has accepted the order and the order is not changed.
Plus, in fact, two full submissions. Since this has fallen for the first time, today is the 24th day of my custody in civil prison. Plus, this may be kept at large. Meanwhile, they may be released. For as far as condition is concerned, because I am relying upon the judgment of the coordinate bench.
No, the thing is, Mr. Advocate,
Please, Your
I had earlier also mentioned to you
please.
that you had to deposit that 5 lakhs first, which was told to you in
No,
March.
because in fact, because this is not a case where the court has, because that was pertaining, I
This
suppose.
is what RERA or
No, not RERA. I am
Oh,
sorry.
okay,
Because this
okay.
is 39-2A, original application before
Yes.
the learned trial court. 39-2A, I was sentenced for 1 month civil prison. I was taken into custody on 9th of May. No sooner I had filed appeal on the very same day. Somehow, because there was some confusion with the learned appellate court, therefore it could not register. It was registered on 11th. The learned appellate court rejected and confirmed the order of the learned trial court. Because today the position is, I'll just to make sure, because as per this judgment of the coordinate bench, para 33 and onwards.
Are we going into the merit of the case?
Because no, today, Milos, I am to only urge to your lordships that for time being they may be released.
Yes,
Otherwise,
so
there
that
will
is
be.
what you said.
I'll take instructions and I'll file additional affidavit as far as amount is concerned, because the learned trial court or the learned appellate court has not found that you have to deposit. My case is that I am in possession. I was not in knowledge of this order, and therefore, Milos, at the time of also I have stated, and these are not admissions. Plus, there are judgments to the effect that even for admission, this I am supposed to be given a hearing.
Possession has been taken away or something like that?
Lordships, that is the difficulty. Lordships are kindly, which is the case is treated as if there was an order of status. There was no order of status quo. On the contrary, the order was specifically restraining him. Honorable court may kindly come
If
to
my
662.
learned friend is making a statement that he is in possession, I would say to balance it, lordships may say status quo as on date.
There is an order. There is an order. You have not challenged the order.
There is no order. In fact, an injunction is operating. Therefore, lordships may say if my learned friend is agreeable for status quo, lordships may take our
that may be an application. On the contrary,
he is not in possession.
Therefore, has to be done. My application is pending before the trial.
I would be happier enough to make a statement that is to maintain status quo. No, it was, I am saying in my pleadings also that I am in possession from the year 2013.
The trial court has not believed it. You have not challenged the order. You have accepted the Exhibit 5 order. Way back in 2021. Watches may kindly see page 64. What is the order passed by the learned trial court? Paragraph 2. આ કામના પ્રતિવાદીઓએ જાતે કે તેમના માણસો નોકરો એજન્ટો મારફતે મોજે સોએન્સો વાળી જમીન પૈસા વાળી મનાઈ અરજીના પેરા નંબર 1 માં જણાવેલ દાવાવાળી મિલકતનો આ કામના વાદીઓએ કબજો ભોગવટો પડાવી લેવો નહીં, છીનવી લેવો નહીં કે દાવાવાળી મિલકતમાં પ્રવેશ કરવો કરાવો નહીં તેવો દાવાનો આખરી નિકાલ સુધી પ્રતિવાદીઓ વિરુદ્ધ કામ ચલાવ મનાઈ હુકમ ફરવામાં આવે છે. Now this order is never challenged. They have accepted this order. The court has not believed their possession. Subsequently, he enters into the premises, harvests the entire crop that is cultivated by the present respondents, original plaintiffs. An application under Order 13 and Rule 2A is moved. He has the audacity to accept by way of a written reply that yes, sir, I have done it. But the possession is with me prior to filing of the suit, which the court has already not believed. And that order is accepted by you.
And this is construed as an admission on my part without giving an opportunity. It has to be culminated into civil miscellaneous application under section 141 of the CPC, which is not done by the learned trial court. And on the basis of pleading, I am saying those are not my admission. I have stated so. Even in my written statement, I have stated so that no, I am in possession.
Then this order, has it been challenged before the district court?
No, not till date, because he was
No.
not in knowledge of this order. That is my case.
No, you were in the suit. You were served
Yes,
notice. Your
It's a bi-party order.
argued.
Yes, yes.
બંને
It's a
પક્ષે વિદ્વાન વકીલની લંબાણપૂર્વક દલીલો સાંભળી અને પછી you say that you were not in knowledge.
Because in fact, this was not conveyed that an order of status quo has been passed.
Status quo, no.
Yes.
Where status quo?
Because in fact, what my learned friend is relying on, 64, he has stated of an order passed in November 2021. Here I was heard. I have stated that no, I am in possession prior to the order passed and I am harvesting the crop and I hold the possession from the year 2013 on the basis of an agreement of a lease deed of 99 years, which was executed between the defendants and the plaintiff.
So this order dated 1st November 2021.
Is not challenged. For a reason, lordships may consider. Because the former pleader has not informed. On the contrary, if your lordships would call record and proceedings, my lords, the written statement is also filed by the pleader.
So written statement you filed.
Yes,
But then
yes.
you
So-
don't go to see what the court has passed.
Plus that is,
And then you are not even challenging the order.
Yes.
So it is,
plus they are in
But the-
custody, your lordships. Because now even if,
when this order was 1st November 2021.
yes, that one. But from 20,
9th of May 2023.
please. Plus that was not challenged. I have to
So
consider.
that is accepted. It's
No, plus now,
final.
plus assuming that your lordships would consider Milos the period of COVID and the limitation has started running from May 2022. Then also Milos, May 2022, it has Milos started running thereafter.
Still 1 month.
Yes,
Still
yes.
1 year, neither the revenue entries
But
that are
today-
already there.
Now what relief can you get here?
Milos, in fact, Milos,
It's an
Yes,
admitted
sir.
position that he is in breach. Therefore, candidate
No,
who had
not-
submitted, I had conveyed it to my client that this can be done. If he is not in an agreement to this, then the matter has to be proceeded on.
Proceeded on merits, yes.
Right.
Some conditional order will have to be passed. If
Milos,
at all you
but
think
he
it
is
a
asking for,
contract,
Milos, that was not even the crops. I have the receipts of the crops which I can produce. This is not an amount of 5 lakhs of rupees. Now he is making a statement or a proposal that you first deposit 5 lakhs of rupees. Milos, my case is very much,
Saying that the
even if
amount will be given to
94
me, it may be deposited before the.
even if,
To
even
cut
if,
short the issue,
Milos, but
otherwise the
they are-
matter has to be proceeded
Milos,
on
that
merits.
other RERA also you have appealed.
no, Milos, one Mr. Deepak, I suppose, in RERA I was not there.
Mm.
I remember that matter since I was here.
Yes.
Milos, that RERA builder of Ahmedabad.
Yeah, so now here some condition will have to be passed.
Very well, Milos, I am in custody. I may be given Milos 10 to 15 days to arrange those amount and Milos lordships may appropriately Milos, I'll deposit the amount. Because my case is Milos that the crops which were harvested, Milos, that was not tantamount even of rupees 5 lakhs of rupees.
So how much was it?
Milos, whatever your lordship, 1 lakh or Milos 1.5 lakhs. And I'll make an application appropriately applying the mine. No sooner they are Milos released.
In fact, you should be ordered to give back the.
Because therefore, if my learned friend is saying,
An undertaking, that he may give an undertaking that the order will be complied in the letter and spirit, subject to he wants to challenge.
no, if I
So,
challenge,
but till
if
that
I
point of
challenge
time,
it,
we'll have to do
because
it.
I have remedy of 39(4) also.
Otherwise, there
the
is no
court
point of
even-
passing all this order.
Even if the learned trial court has granted Milos, the same court has the remedy Milos to modify it. I will apply no sooner.
Thereafter.
No, but
Yes.
it is not done. The thing which cannot be on the basis of what is going to happen tomorrow, my learned friend may not make. Plus, Because my apprehension is that assuming that my client would pass this sentence, because no sooner tomorrow they will come and because this will be in the form of multiple litigation. They will make us another application by the time I challenge. Because there is a serious dispute of possession. I hold the possession. Therefore, I am very happily making a statement that let parties may directed to maintain status.
Cannot be done in
No,
this.
no, that is the thing. Status quo means that will be with you.
એને જે
Status
કર્યું એને
quo,
મંજૂરી આપવાની વાત.
he asked for status quo.
No, plus it is not snatch away. I am saying consistently, even at the time of contempt, even at the time of filing my written statement, that I hold the possession prior to the filing of the suit. And I understand what has fallen from your lordships, that Exhibit 5 order has attained finality. That is not challenged. Plus, therefore, I have passed almost two-thirds sentence what has been imposed.
And the crops, what were the crops? By way of this petition, the petitioners have challenged the order passed by the learned second edition dispensation.
Younger no part, page 68, para 7, along with
On
the
25/20/23. At exhibit 18. In miscellaneous civil appeal number 1/2023 and the order passed by the learned.
High Court order is at page 73.
73 by the learned. Additional civil judge Dabois on 24/20/23 at exhibit 29 in regular civil suit number 14/2018. Next paragraph. Heard learned advocate
DK Dave, Dhruv K. Dave.
for the petitioners and learned advocate
J.U. Bhatt.
Mr. J.U. Bhatt for the respondents. All the respondents? All the respondents. Next paragraph. It is the say of the learned advocate for the petitioners that the order passed by the learned civil judge. Learned additional civil judge Dabois on 1/11/2021 below exhibit 5 in regular civil suit number 14/2018 has not been challenged. And it was the contention of the petitioners who are the original defendants in the suit that the possession of the disputed suit property is with them since long and they have harvested the crops. They have harvested the crops. Next paragraph. Learned advocate for the respondents, Mr. Sambat J. Bhatt has submitted that the respondents who are the original plaintiffs of the suit are in possession and they have been dispossessed after the order passed by the learned civil judge. The matter requires consideration. Next paragraph. The matter requires consideration. And as the petitioners are in civil prison since
9th of May.
9/5/2023, it would be appropriate if an order, a conditional order for them to be released is passed. Next paragraph. The petitioners are ordered to be released on the petitioners depositing an amount of rupees 2 lakhs.
Page 68, I have mentioned my loss.
Because it is of actually it is 3 lakhs. My learned friend told me was 5 lakhs. Plus
3 lakhs. Okay, 3 lakhs.
not 3 lakhs. Therefore, I made 1.5 lakhs was reasonable. They will have to regenerate the funds once they are out. Therefore,
So
Two
matter
lakhs.
of fact,
Very
it is reply He has stated that I am not under an obligation to return that amount because prior to that.
2 lakhs with the learned additional civil judge Dabui
Please,
within a period of
15 days from their release.
15 days from their release. The amount is to be kept as a deposit
Yes.
till final disposal of the suit. This can be disposed of, no? If you are listening. As such, the 9th, they will finish this thing. Meanwhile, you challenge that. order.
Yes, yes, please. This may be disposed.
Yes. With these observations, the matter is resolved. The matter will deserves consideration and conduct.
Please.
This, at least, Milos, this both orders stands as on date. So some
Yes.
observations that Milos, that may not come in a way at the time of further hearing of the suit.
Will stand.
The
Because
petitioners have already undergone the sentence for a period of 23, more than 23 days. And hence, the orders are not to come in the way of any.
please,
It is, this court has not gone into the merits of the case.
please, much of.
Those application may be decided independently.
Yes,
Because even my application for status quo ante is pending.
Okay.
Those
Those, yes, those
applications
applications may be decided on merits
Right.
without being
may be decided.
influenced by any observations of this court.
The lordships can observe that aspect.
Yes, it is.
Please.
The applications, any pending applications in this suit will be decided by the learned trial court without being influenced by any observations made in this order.
Please. There's one unreasonable request, direct service today, Your Lordship.
Direct service permitted.
Grateful, grateful.
Assumption. Yes,
Lordship. Application number 1 has purchased the any land in the year 2020. And he has constructed kacha shed of 43 shop of the photographs of the shop
yes.
and present.
Photo bata do.
It is only kacha, no permanent structure has been made. Now, furthermore, my lord, that these premises are situated in the rural area, very in the rural area of village Balkotra. Now, this land is not covered under the land Nagaratna, Mahavati Nachi Sahib. એટલા માટે we are not required to seek any permission under section 27 of the act. That I will, with my lord permission, section 27, I may permitted to read.
No, what is the notice you are challenging? What is the notice you are challenging? What is
Notice that they have said is at annexure A. આથી તમને નોટિસ થી જણાવવામાં આવે છે કે મોજે ભરકટાના રેવન્યુ નંબર 63 માં પતરાના શેડ વાળી લગભગ 43 દુકાનો બનાવી બાંધકામ કરે છે. અત્યારની કચેરી દ્વારા સ્થળ નિર્ણય કરતા સ્થળે હાલ પતરાના શેડ નાખવાનું બાંધકામ ચાલુ હોવાનું માલમ પડે છે. તેથી ગુજરાત નગર રચનાની વિકાસની કલમ 36(1)(2) હેઠળ મને મળેલ સત્તાવન હેઠળને ફરમાવું છું. બિનઅધિકૃત બાંધકામ દૂર કરવું, સ્થળ ચાલુ બાંધકામ બંધ કરવું, બાંધકામ પૂર્ણ થાય તેવા રહેણાંકની નીતિમાં ઉપયોગ કરવો નહીં અને ઉપયોગ so I am directed within 7 days.
yes?
Now if I do not comply with the direction according to them, my all these shops will be sealed, either sealed or the removed or demolition will be done under the provision of the act. For my submission to my lord, that this act is not applicable to the present thing. And I have constructed premises in 2020. They are coming open in that area, but they were never objected. For the first time in the month of 2023, અત્યારે આવ્યા સાહેબ અને they started this first. So I challenging that this is the notice is without jurisdiction, without any reason, and it cannot be causing this notice should be caused.
Issue notice. We'll issue notice to them because the,
I
anyway, the
mean,
notice that you have been,
I may be protected by
no, the notice is dated 16/3/2023. 16/3 તમને નોટિસ આપી હતી બરાબર અને ત્યાર પછી તો કઈ થયું નથી એટલે નોટિસ નોટિસ કાઢવાની છે
direct service.
રિટર્નેબલ લોન વેકેશન પછી 14
Obliging.
14 June
Obliging, my lord.
direct service permitted. Somebody is here.
As per the suggestion of the college, I have already paid the late fee of rupees 71,500. As per the suggestion of my learned friend, that the fees are paid less at a belated stage. Therefore, the cost is to be and the penalty is to be paid. I have already paid. I have already shown the receipt to my learned friend.
There are three issues. One, in the petition, my learned senior has taken an issue that no hearing was given. No show cause notice was given. He submitted a reply. Was
That yesterday itself I had said.
Procedure has been completed.
Yes.
Merely because the stand of the petitioner is that the fraud was played upon the petitioner by a third party. We have insisted that a FIR may be filed to show their bona fides. If they have been defrauded and ultimately we were
Yes.
defrauded.
Yes.
So my lords, the one, they pay the late fee which has been paid. Second, they may pursue and file an FIR to show their bona fides.
I have already filed two complaints.
No, they are filed.
But thereafter investigation will, is it?
FIR.
Yes, that
અરજી આપી છે ને પોલીસ
My lords, urgee is worth saying it is a 1.5 page urgee, not does not reflect the fraud being committed, but I will leave it to the.
Anyway, you
investigation.
have received the late
The
fees
late
also,
fees.
but it is not. I don't know if the petitioner is here.
petition is
He is here.
easier.
Where is he? He is a doctor.
Yes.
And it is not, see, we expect, at least the society expects some people to have some ethics. Okay. This is not the way. You are going to an educational institution.
Right.
Okay. This is not the way to go around. Now, the college has come, the late fees have been paid, so you have no issues. Now, what about his suspension?
My lords, we may permit them to appear in the exam. That
In
the entire reason for suspending the student was that the bank statement given to us was a fabricated bank statement, which even the bank has. agreed upon.
Exactly my query yesterday, that who was the one who went and who gave this?
The petitioner provided the
fabricated-
statement
Yes,
to the college.
But that was given by Ramesh by Maya
But
to me.
how-
Therefore, I have.
See,
He-
again, you are acting like a post office, somebody
Correct.
gave me something, I went
Correct.
and gave.
that
Whose responsibility is it?
no.
Is it not the responsibility of the petitioner?
Kindly visualize from this angle also, that when a person has shown us the two checks, that I have already.
See, you are not an uneducated person with a
Correct.
thumb impression.
No,
You
that-
do not
that's-
know. It was your bounden duty
That
to
was.
pay the fees.
Oh, yeah.
You
I-
and you are already a
sorry.
postgraduate student.
I'm sorry. What has happened, your lordship? The two checks issued from the Axis Bank of the Ramesh by Maya, he has given it to handed it to me, and I have handed it to the college. Thereafter, I went for the receipt, asking for the receipt, because he has already given me their statement that it is credited, it is debited from his account.
I may just
Therefore-
correct the record. The checks were not given to the college. either the said Mr. Ramesh or the petitioner deposited the check directly with the bank.
Yes.
Subsequently, it came to our knowledge that the check were bounced. It came to our knowledge after the fabrication, when the student had come pursuant to the show cause notice. So checks were directly deposited, they were bounced, we were not aware. They came for the receipt, they gave us a fabricated statement. We checked with the bank said this statement is fabricated. No such.
Otherwise, a family coming from the doctors, at no point of time, he is also a student of MBBS from the very same college. And in MD also, he is pursuing his study from the very same college.
Okay.
These past
So you
papers,
say that you will permit him to appear
Yes.
for the examinations,
Yes.
correct?
My
Which
lord.
is your prayer.
yes, which is my prayer. And so far as suspension is concerned, the impugned order is concerned, that without inquiry, that can be gone into at a later point of time. But I may be permitted to appear in the examinations which is commencing from tomorrow. University is here, so hall ticket may be issued. They may permit us to appear in the examination.
No,
That
they
is-
may appear in the exam. Inquiry is over, we have passed an order that may be placed on hold. They may file the necessary FIR. They may show that they were indeed
Okay, that-
defrauded. Until they take remedial steps, my lords, we may then withhold their result.
But
If
that-
they
that-
are able to,
but
they may
that
appear
is-
in the exam, my lords, the result is going to come after 2 months.
But
the
my
meantime,
the
they
In the
pursuit
meantime,
of-
we will have another hearing. Yes.
Yes, yes. And my learned friend is insistent that FIR is to be. I have already made the complaint.
That is,
So that
their-
is that subject to that is something unusual and beyond.
No,
that
it is
can
not-
be seen
Yes,
at
yes,
the
in
next.
the
hearing.
after-
Now let him appear
Correct,
for the
yes, yes,
exams.
yes.
The petitioner has filed the present petition under Article 226 of the Constitution and has made the following prayers. Next paragraph, notice has been issued and learned advocate,
Anuj K. Trivedi.
Mr. Anuj K. Trivedi has appeared for
This one number one.
Number one,
One.
in university, my learned.
Yes, now corresponding number two.
Mr. Learned advocate, Mr. Vikas Nayak has appeared for the respondent number 2. You have nothing to state
No,
because it is yes.
no, only the hall ticket, which my learned friend, lista number 1 has to be issued to me because hall ticket is yet not.
Respondent number 2 has to issue that.
No, number 1 has to be issued the
Yes,
hall ticket
that
and I'll
is-
have to submit it to number 2. Otherwise, they will not permit me to appear in the
1 and
examination.
2. Next paragraph. Third, learned advocate Ms. So and so for the petitioners, learned advocate Mr. So and so for the respondent number 1, Mr. So and so for the respondent number 2. Next paragraph. The learned advocate for the respondent number 1 has submitted that the petitioner has paid up.
Has paid the fees and the
Has
late
paid the fees and the late fees. And at present, there is no outstanding amount to be
No.
paid by the petitioner. 2, the respondent number 1 college. Learned advocate has also submitted that in view of this, the petitioner will be allowed to appear for the which exams?
MS Ortho, third,
MS Ortho
last semester,
exams,
6th semester,
6th semester,
6.
commencing from 1st June 2023,
yes.
tomorrow,
No,
Too much.
2023. And learned advocate for the petitioner number 2 has submitted that the hall ticket will be issued,
Yes.
will be issued to the petitioner
Knowledge rights us.
as soon as the college, as soon as the respondent number 1 submits the request to the respondent number 2. Next paragraph. With the above observations, stand over to, let us keep it in the first week of July,
Any.
5th of July.
My lords have recorded that I submitted. My lords may just state that on instructions.
On instructions from the authorities, learned advocate for the respondent number 1 has submitted.
I would
I share
hope that in the meantime, they may take actions if they have been defrauded and we have been.
That is already done, your lordships. And I'll pursue that, the
Lordship.
necessary action should be taken by the police authority.
Lordship, oblige, my lords.
Number 9, 96 your
They are taking direct service of the order.
president.
They are here,
Direct
but at the
service.
same time, the direct service.
Your
Yeah, they are-
Wakalatnama needs to be
yeah,
filed.
they are here.
I have, in the morning, I have filed.
Okay.
Lordship.
Please, I may be permitted to appear on behalf of my Supadhyay. Land grabbing act petition challenging the wires. requesting for interim relief at this stage.
What interim relief?
Also to stay the proceedings which have been initiated by the collector. The notice is on page 33.
No, why should it be said? Have you gone there on the 25th?
Please, Lords, we appeared
Yes.
on 25th. Lords,
Yes,
in the
okay.
connected matters, there are approximately 527 connected matters, and the issue is pending before the division bench, wherein stay has been granted. May I just supply the orders?
Then let it be before the division bench.
Lordship, may
As of now, to this cannot be stayed because
Lords,
25/5 is already gone.
sorry,
You had to appear before the
I
collector.
have appeared. It is kept on 1st of June. Next hearing, the next date of hearing is 1st of June.
So appear and put forward your case.
Please, Lords, we'll do the needful, but as the virus has been challenged, it needs to be stayed. In the identical petitions wherein I had an opportunity to assist. Pass करते
Now,
same orders were passed pursuant to the notice of the collector.
yes, so we will
And-
issue notice. That is what I am saying.
Lords, even stay has been granted to the proceedings. Been ordered. The issue is as such that the event has occurred prior to the time when the act came into force. Therefore, on this very ground, stay has been granted. If your lordships would see the page 34, the act, last line. It shall be deemed to have come into force on the 29th August 2020. So the act came into force on 29th August. The events which have been alleged are prior to the date of this. For that, lordships may peruse page 52. Sale date is dated 3rd of July, which is prior to the August. Therefore, in view of those, interim relief is sought to be granted. There are 527 connected petitions lodged.
Let it be in the beginning of the vacation before the division bench. Yes, nothing, this thing.
Lordships
This
may
also
till
is
then
passed
grant
after-
stay.
Huh?
May I request the lordships to till then grant stay, as in identical 527 petitions there have been granted stay on this
But
very.
yes, but after giving them an opportunity.
That's
But-
in note advance copy served to the respond number 1.
Learn it, respondent number 1 and the
Please,
others
lordships.
have to be respondent.
I'm only requested, right? This may be requested at your.
Yes, that is what.
Because in the meantime, nothing would happen because it is at the stage of.
And already what he is asking is on the 25th. Now you can't stay that 25th.
No, lordships, I'm sorry, I'm sorry. And the consequential proceedings, my prayer on page 15C paragraph.
To 5th straight away. 5th, let the division bench deal with it.
Lordships, I have even requested the consequential proceedings to be
Yes.
stayed therefore.
On the 5th. DB ने सामने जब तो.
The lordships may consider I have to appear tomorrow before that court therefore.
Appear, no problem. Immediately nothing happens.
Lordships, but it
Next.
can be stayed as such the issue is settled by the division bench as of now.
That, if you see all
Consider.
the orders thereafter.
These orders are ex parte only passed. The stay orders are ex parte only
Why
passed.
or DB?
Please, lordships. Oblige.
આપી દો. હવે શું બાકી છે આમાં શું થયું?
I've taken instructions. As far as the original PDF is concerned, we've got the screenshot. It is 703. And as far as this video is concerned, we have sent somebody to actually look into the time which has been recorded. Lordships may see the date of download, time of download, and the details there, left hand side. It's 703 here.
Okay, we'll keep it tomorrow or
Yes, we may keep it because I have to place those things on record.
yes, with his affidavit. Keep it tomorrow.
The only difficulty would be, my lord, that
I get the confirmation on email, I will get the affidavit, so I may be permitted to produce that.
My only difficulty.
No, I will be forwarding it to you
No
in
dispute.
advance.
But the problem, I'll have to still meet with it. Or may I just, I take it that my senior friend is taking a position. Only one fact which I understand my senior friend may put it on record. I've understood, so I'll be meeting with that by tomorrow morning. That the video recording which is shared with him is at 3:07.
307 and the NIC's report and all that,
Okay.
which has been produced by me, which the
Okay.
copy is already given.
Correct.
So I have to.
Salman,
That Malad we will back.
No different.
The honorable court may not.
No, logs are not in dispute. They stand as they are. The request is, I'm meeting with the contention that the screen recording time is not 3:07, but it will be 7:03. As far as the PDF is concerned, which is downloaded as on computer, I'm getting the screenshots, additional screenshot for my senior friend also by tomorrow. Any other thing I may not be able to deal because these are certain things which I am not a privy.
You may not deal with because as a examining agency, it is we who are reporting on record.
Allegations on record, and if required, I'll get the 65B certificate also. That
okay, you can give it in advance.
I'll
whatever you
so
have to give.
I may not be
check.
said that I have not dealt with X, Y, or Z, and therefore the only worry is that there's no difficulty. I understand my senior concern that if it is 3:07, the document is of 3:07, how do you download it at 7:03? I've understood that. I've said
Yes.
that the email is much prior, so the complete theory falls. It's perhaps, I'm not sure. We are still getting the original computer check, but the oral instructions are which I would not make a statement, but perhaps it's quite possible that we would have copied it. And that's the time because it will have to be shared. It was shared with them.
Share is the same. You have to share the same thing. Yes.
Let's I'll get that.
Come back to me.
I will come
Whatever
back.
with whatever.
The only request which I am making that if the physical affidavit is not available, I will produce the email
Mail.
duly affirmed by them and send it to me on.
Yes.
There I cannot have any.
Yes.
Yes.
And I will also send advance copy to my London.
Yes.
Obliged.
Please don't. We are immensely obliged for a patient hearing. But एक copy जो आपको email तुमने email करा.
हाँ.
Losses are keeping it tomorrow.
Come tomorrow.
Please.
Any mention? Let us finish that. Then we'll go back to 15, 16.
Requesting for circulation for matter, but tomorrow, day after tomorrow, it is in the Town Planning Act. Against the draft scheme, I have filed my objections. Now, pursuant to the act, the possession is required to be taken after the draft is final. Now, at the preliminary stage, the notice has been issued for taking away the possession for the purpose of widening of the road. These are the residential houses of more than 100 years old, my lords.
On
These
second.
notices have been served through affixation on the
Which date notice?
20/20/05 Dispatch.
So then till today, what are you doing?
But the
Dispatch
difficulty,
notice
the
given.
petitioners were out of their residence because of vacations. And they have returned only last week, my lord, somewhere in 25th or 26th.
Second, on second.
Second, very good. I'm good. First, that type copy dispensed with my lords. I'll
you
keep
enough
ready.
time.
I'll keep ready all the type copy before the hearing. my lords.
Is it filed? No?
Yes, ma'am, it is filed. Number, it is already
filed.
numbered.
Okay.
There are two petitions, my lords.
Okay.
Please, Lordship.
So seeking urgent circulation of a matter under surface yet, Lordships. The creditors are going to are conducting auction. We have received notice long back, but then we have approved the DRT. The DRT is not proceeding with the matter, Lordships. Section 17 is already filed.
DRT is not proceeding with the
We are
matter.
creating
DRT is
third
not
party rights by doing an auction, conducting an auction.
on second.
And Lordships, typed copies of this last week.
You have enough. Is it filed?
It is filed. Lordship.
Okay. You have enough time. Huh? Legible copies should be there.
Lordship has granted second circulation of second appeal on first, but Lordship difficulty is registry has raised objection of certified copy of decree. I have placed a certified copy of judgment, but
Decree.
Lordship,
No, without the decree, so how can they?
Lord,
even
certified
admit?
copy
That
of
is correct.
judgment is
The
there.
objection is correct.
Lordship,
get the
but I am
decree.
requesting for dispensing
No, it cannot be. Decree has to be there.
decree, certified.
It
Lordship,
will be an objection only. Get the decree.
Lordship, some
No, that cannot be. Yes.
Requesting urgent circulation of fresh first appeal MACT matter. Lordship's difficulties this way is that we are facing execution proceedings and the executions proceedings are listed on 5th.
Where? Where are the
Fee-
execution proceedings? Before
Please,
the tribunal?
Rajkot.
Yes, to go before the tribunal. Face the
Please,
Uh,
the difficulties this way is that the award amount is sizable. With interest, it would amount to rupees 1 CR, which would require 3 tier approvals of the head office.
what is this?
It's a first appeal, please.
Insurance company.
Please. I'm on behalf of insurance company and we have preferred appeal.
But what immediately they are not going to take a Japti warrant
At least
against.
some relief may be
No.
granted.
No,
at
no, no,
least
no.
Your
No,
ladyship
insurance
may,
companies,
please.
you have delayed so much and then come. at
The
me.
matter is not with the delay. The matter is in limitation
Yes,
within.
but imagine the plight of the petitioners, the applicant.
Please,
No.
my lords, it is only that conditional stay we would be requesting.
No,
that
conditional
please.
stay.
Then in that case, may I only request that matter may be listed on 5th on the reopening. Only request because since we are facing execution proceedings, so I am requesting.
You have already filed it.
Please, I have already filed. I've cleared all the office objections also.
Huh? Nah. But,
Please,
go to the
at least
regular-
on
go to the
because on the
regular
same day we would not be getting it would be practically difficult for the bench also to call for the file on the very same day and
That's not urgent.
please I'm
Next.
only
Lordship, I'm in
He's on-
process to file the application.
Then file it. No,
Lordship, there's an extra urgency in this matter, Lordship. They would be taking away my possession on this and they have issued a notice on 24th.
but
they have-
file it, then come.
Lordship,
You
the-
have to file it and then come because there's a lot of other problems that everybody
Lordship, I
faces.
would file it today, but I would request the urgent
No.
circulation of.
Without filing, no.
Yes. I am requesting for circulation. Yesterday, your lordship was kind enough to grant me circulation for second, the cancellation of registration of a minority school. But after we had gone, the registry does not accept filing after 12:30 lunch.
So file it today.
We have already filed it. There are no office objections. So may I request that it may be listed on second?
I've already said
Yes,
second.
yesterday. your
Yes,
lordship
then
said that.
second.
Yes.
Okay, તો હવે second ના આપી દો. હા.
I will mention.
Filing number આવે ને પછી જ તમે સહી કરજો.
Sir, requesting for circulation upon PASA matter, my lord. My lord, the difficult.
Pre-post.
Post, my lord. A paper book may be dispensed, my lord, as we have not been supplied of the certified copies of the paper book, my lord, from the collector office, my lord. Therefore, my lord, that paper book, we have annexed original order of the PASA as well as grounds, my lord.
They are not giving them the paper book.
My lord, we, as and when, my lord, that objection raised, my lord, as and when this, as and when registry raised that objection, again, my lord, we went to the collector office officials said that we are not giving certified copies of the paper book. We used to give the copy of the,
Certified copies they will not give.
my lord, registry has raised that objection, my lord, therefore I am requesting, my lord.
Certified copy તો નહીં આપે ને એ લોકોને. Paper book you have put?
Yes, my lord, paper book, we have,
Okay.
that may be
Put the
dispensed.
paper book, yes. Certified copy તો નહીં.
My lords, may day after tomorrow, that paper book may be dispensed, my lord.
Paper book
Paper book
મૂકો.
તો
Certified ની જરૂર નથી પણ paper book put the paper book.
એ મૂકી દીધી છે સાહેબ પણ એ ઓબ્જેક્શન સર્ટિફાઈડ નું એવું છે already filed that paper book is also filed.
Okay.
Yes, my lord, and another same request for that,
હજી છે એક matter.
another request is, my lord, same PASA matter, certified copy and everything is put there, requesting for circulation, my lord.
Post.
Post, my lord,
Second.
please, my lord, grateful.
ચલો હવે password matter. Anything else? No, okay. Come on. This.
Lordship, may I have 9 to.
Mr. AGP, any news from that PGVCL? Okay.
I have communication, but we will also take instruction from. This can be tomorrow.
No issues, my lord, if it is kept tomorrow, we are just running against time. The tender closes on 2nd of June, that is day after tomorrow. We have already moved them twice with seeking rectifications and clarifications, to which they have not responded till date.
See, these matters were allowed only because of one issue, not going into the conditions and the terms and conditions. It was only on one issue, that the tender closes on 2nd, but the portal is not working. And because of that, you were not able to participate in the process. And that is why notice was issued, because I just wanted to tell them that in case the portal is not working, then it would not be fair to you. If all the terms and conditions, that will have to be gone into detail. Whether they are proper, they are not proper, you are being blacklisted, whether it should be there, not should be there. That all requires a lot of this. It was only for this limited issue that the circulation was allowed, because in case the portal closes on 2nd, or the portal was not working and you wanted to submit your online tender, this is again, it was argued that only online tender has to be free.
It's an online tender.
Correct. So now if they have closed the portal, then they be directed that open the portal, if necessary, go to their office, sit there on their computer and you upload your tender. That was the only limited issue. Yes.
CMO to PGVCL extended the date. Actually, the real date to open the tender was on 26th.
Yes.
And that is why the matter was being listed on 25th.
Yes.
Now, since PGVCL itself has extended the date up to 2, they may be extended after vacation.
If they are here.
I would just like to clarify that my instructions were never that tender portal was not open. So
nor have we ever
nor
mentioned, my lords, regarding.
Not you. Then I allowed yours because I had allowed this.
Therefore, I'm saying, my circulation was not based on the
Yes.
premise
No,
of
it was,
law.
that is what I said. See,
May I submit? My instruction is that there are 3 necessary conditions incorporated in the tender. Condition number 1, that condition number A, the entire process should be online. Condition number 2, the 1 to 9 documents which are referred in clause 8 has to be submitted online.
Yes.
Now, the portal is not working, and if we are not able to submit it online, we cannot participate. And Article 14 strike immediately, my lord. So that is why my humble submission is that in my instruction which I have received, condition number B, entire tender is online, but condition number B, through which we have to submit our document, are not accepting, my lord. And that is why this engineering association can participate, my lord. So even if this matter may be kept after vacation, we are not missing, my lord. But they should have to maintain status quo. That is my humble request to Honorable.
no, not like that. No status quo and all. If they were present, I would have told them
For the
to
time
allow.
can go tomorrow.
Yes, it can go
Sure.
tomorrow. Tomorrow, please ensure that they are, whoever is the advocate
I
is
will
present. Yeah, because this is a very small issue what has to be dealt with. In case, since the request is that the portal is not working or the 129 documents are not being uploaded on the portal, that requires a little this thing. Okay.
Well, only for 2 minutes. One condition is that the shares of their individual ownership. Now that is against
It is again, see, that again will have to go into detail by the, it will have to go into detail because you are challenging.
Some condition has to take it of course. That is what the Supreme Court has given. And I have on my hand.
It can be considered after hearing the parties, not at an ex parte stage.
Well, they are
with a prayer that this is
supposed to be present, my lord. Once notice has been served, of course, in my case.
Let us see tomorrow. Yeah.
My lord, tomorrow.
Tomorrow or day after.
If the tender is closing on 2nd, so tomorrow will be.
So day after, if they are here, they will.
But then there would be no room for me to.
Again, tomorrow it's a very heavy board with a lot of cases. So then I may not be able to.
It may be kept on today, day after tomorrow, my lord.
Day after tomorrow.
My lord,
Let them remain present.
my lord.
Just apprehending that if it is the last day, my lord,
Then there will be not much room to do anything, Lordship.
I appear for the association, my lords. My only concern is that let on behalf of 100 legal entities whom I represent, let there be a pre-bid meeting with them. My apprehension is this, my learned friend is directly arguing on Article 19, violation of Article 19 and 14. In a way, we are in.
Okay, let it come. Let them come.
Please, my lord.
Second.
Second.
Yeah.
Second, my lord.
हाँ.
Second.
बंद करिए. Okay, second.
My lord, order to inquire whether the notices
Good morning, everyone. Am I audible? Yes? Can you see the screen? Okay. So welcome to the analysis of the Union Budget 22-23 Part 2. In the last week, we had carried out the analysis of the Part 1 of the budget. And in the last week, we had discussed two important themes from the budget. One theme was with respect to the infrastructure sector, and the other one was with respect to banking and finance. So in today's class, we will be covering the remaining themes from this year's budget. So by the end of this particular class, we will be done with the analysis of this year's union budget. And next Sunday, we'll start with the analysis of the economic survey. Okay. So before starting with the class, two important announcements. I hope all of you must be knowing that pre-prediction test is live, right? So in case if you are not yet attempted the pre-prediction test, please attempt the pre-prediction test. So today is the last day. So some of you must be waiting that I will do a perfect preparation for the prelims and then I'll attempt the pre-prediction test. Please understand there's no concept of perfect preparation for the prelims. The preparation is always a continuous process, a continuous improvement. So do not wait for that kind of perfect preparation. Attempt the test, get a reality check as to where you stand in comparison to your competitors. What is your level of preparation? So that reality shock is very much important because when you get to know your level of preparation, you will put in far more efforts because the last 100 days are extremely important, as you know, for the prelims part. So this was the first announcement. The second announcement was with respect to the quiz for the Union Budget 22-23. So as promised in the last class, we have already uploaded the quiz for the Union Budget 22-23 on the eLearn platform. Is my voice audible, all of you? Okay. So we have already uploaded the quiz for the Union Budget 22-23 on the eLearn platform with respect to the first class. And by the end of today's class, we will be uploading the second part of the quiz as well. So please attempt the quiz. So we have approximately around 35 to 40 questions from this year's Union Budget. Attempt the quiz so that you are able to correlate the things which you have understood in the class with the quiz. Similarly, when I take up the discussion of the economic survey, once again, we will have the quiz on the economic survey as well. So by the end of these sessions, that is with respect to budget and economic survey sessions, my idea is that you should not have to look out for any other source except the class and the quiz. That alone should be sufficient. You don't have to look out for any other source, both for prelims as well as for the mains examination. That is my idea. Okay. So let's start with the analysis of the second part of the Union Budget 22-23. So as discussed in the last class, we have discussed two themes, that is infrastructure and banking and finance. In today's class, we shall take up the discussion of the remaining themes. The first and most important theme that we will take up for today's discussion is the theme of agriculture sector. Now, before discussing as to what all initiatives the finance minister has announced with respect to the agriculture sector, let me give you the background and make you understand as to what was the priority of the government with respect to the agriculture sector. See, we all know about the Green Revolution, right? The Green Revolution has led to a substantial increase in the production of food grains. From a net importer, India has become a net exporter of food grains. But the Green Revolution, in a way, has led to a kind of agrarian crisis. What problems the Green Revolution is causing right now? First and foremost, if you see, the farmers, particularly after the Green Revolution, they are using more of inputs, such as, say, water, fertilizers, insecticides, and so on, because of which the Indian agriculture is becoming environmentally unsustainable. That is the first problem. Second problem, because of the Green Revolution, the productivity of the Indian agriculture is coming down because most of the farmers are practicing monocropping. For example, if you see rice and wheat, these two crops alone account for 38% of the total cropped area in India. So there is less focus on the diversification part. The third problem is the income levels of the farmers have not increased. So Green Revolution has led to environmentally unsustainable practices. It has led to monocropping system, and the farmers are not getting good prices on their agricultural produce. As far as the prices for the agriculture produce is concerned, you must be knowing that earlier the government had introduced the 3 Farm Acts in order to liberalize agriculture marketing regime. But there were a lot of protests against these 3 farm laws, and ultimately the government of India succumbed to the political pressure, and government has repealed the 3 Farm Acts. So this part is left out. So now tell me, if you were the finance minister of India with respect to the agriculture sector, what would have been your 2 main priorities? One priority would be to make agriculture environmentally sustainable, right? To reduce the input cost. That would have been your first priority. The second priority would be to promote crop diversification to enhance productivity, right? So this year's budget has focused upon these 2 aspects. That is to reduce the input cost of agriculture so as to make agriculture environmentally sustainable. And second, to promote crop diversification. As far as marketing reforms is concerned, marketing reforms as of now, it has taken a backstage because of the protest. So let's understand as to what all initiatives the government has taken, particularly with respect to these 2 parts. So to reduce the input cost and to make agriculture environmentally sustainable, this year's budget, the finance minister has announced that we will promote natural farming across India. So that is the most important initiative. And in order to promote crop diversification and to enhance the productivity of the Indian agriculture, the finance minister has announced that we would focus upon the diversification of crops towards millets, which are also referred to as nutri-cereals, diversification towards the oil seeds, and also introduction of drone technology in the Indian agriculture in order to improve the overall status of Indian agriculture. So broadly, these are the major initiatives. Now, why do these things become important? If you have seen this year's mains question paper, you must have come across a question. The question was, how do the emerging technologies help in the crop diversification? I hope you must have seen this question, right? How do the emerging technologies help in the crop diversification? So 2 things are important: crop diversification and the emerging technologies. And this year's budget, you have seen one emerging technology which we are using is drone technology, and the other aspect is we are promoting crop diversification. Can you see the linkages here, right? So that is where you have to interlink the budget thing to your UPSC syllabus. If you just understand that we are going to promote drone technology, it's not going to help you. If you are going to promote crop diversification, if you just know that, it's not going to help you. So let's simplify these things from the perspective of your UPSC prelims and the mains examination. And I'll also tell you in what way questions can be asked from these budget announcements. Are we clear on this? Okay, so let's start our discussion. So as you can see, with respect to agriculture sector, these are the important initiatives and some minor initiatives. We'll not discuss much on the minor initiatives. We'll focus majorly on the major initiatives. Okay, fine. Look at the 2 questions which you can see on the screen. Okay. So, as I said, in this year's budget, the finance minister has announced that we will promote natural farming in India. So, in what way this particular topic of natural farming becomes important from the perspective of your UPSC prelims examination? So, in what way questions can be asked as far as natural farming is concerned? First and foremost, UPSC could ask you a question with respect to what is the difference between organic farming and natural farming. This is one thing. Second, UPSC could ask you a question with respect to the initiatives which the government has taken for the promotion of natural farming in India. So let's discuss these things. See, as far as organic farming is concerned, to promote organic farming in India, the government is presently implementing a scheme known as Paramparagat Krishi Vikas Yojana. Under the organic farming, what we do is, when the agricultural commodities are produced through organic farming, we provide for certification of the organic products. So we need to certify that the products have grown through the organic farming. so that the consumers who are buying the organic products, they need to know that these are genuinely organic products. So with respect to certification of the organic products, we have one program known as National Program for Organic Farming, NPOP. This particular program provides certification for the organic products which we need to export to other countries. So whenever organic products are to be exported to other countries, the certification is given under National Program for Organic Production. This is under the Ministry of Commerce and Industry. And the certification under this particular program is given by an agency known as APIDA, which stands for